Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
No, I am not Peyton Mansley John Milton. I am the agent authorized to represent Peyton Mansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is this
I'm not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
All right. Welcome to the Court of Public Opinion. I am the Recovery Addict. We are jumping right back to coverage of the Wolfenbarger trial, which any second now is going to pop back from break, and we will probably hear an expanded version of a judgment of acquittal motion, which is where the defense basically says, Your Honor, they got nothing. They got nothing on my guy. And in this case, they might have an argument. We'll see. We'll see what happens. We will keep an eye on. We will portal from this one to Donna Adelson if they seat a jury, and so we can get opening statements there. That would be just amazing. And so we're set up to do that. It might not happen till tomorrow. We're just saying. Let me put that out there. Might be today, might be tomorrow when they finally seat a jury. There's a lot of questions and stuff to go over and kick people out and argue over things. So I'm pretty sure the jury might. I mean, if we do get opening statements, that's all we're getting today. There'll be no testimony. Was listening to the scanner over lunchtime, a possible active shooter situation in the University of Tennessee, Chattanooga. They've got all hands on deck over there responding there. So prayers go out to them. Hopefully everyone is safe and that's taken care of quickly. Did the prosecution arrest? Yes, they did. First thing this morning, they had no additional witness. And so we went straight to defense. We've had 2 defense witnesses so far, which has been great. Not the strongest of witnesses. A little, I don't know. It's spent a lot of time with people, and it's not like we're spinning our wheels.
Wanted to see me tied back.
Just making sure that vehicle didn't stop. I was wild seeing the SWAT teams pass by my job. Just Kristen, stay safe, please. Let's see. Don't think it'll start till tomorrow. Just my wild guess. Future. I've heard a couple people say it's not going to start till tomorrow. One of the jurors was told, "You can't. It'll be tomorrow through September 3rd." Is what they're looking for. So that's the Donna Adelson case. We will be following that one, gavel to gavel, as that kicks off.
Now I'm trying to have court. Don't raise your voice again.
I apologize. Judge Clark comes in, tells me to hush. Kim says, "What am I, chopped liver?" No, Kim, you were first in chat again. Congratulations, Kim. I want you to just focus on your job right now. I'm not trying to distract you. Please just fix the internet. Chat is not on the screen. I'll do my job. You do yours. Thank you, Shaky Ground, for letting me know. Kim, you fix the internet. I'll work on this end. So congratulations, Kim. You've won. Once again, you are, in fact, the internet owner. Maybe even the queen of the internet. We'll figure out what your title should be. You win, and you win, and you win. There's a song about that. Like, all I do is win, 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 no matter what. Let's see. They got our hopes up with all the openings on Thursday talk yesterday. Yeah, but they're still... I mean, it's just, we're not there. We've got, if we're looking at, let's see, this is box 3. Currently it's 2. Let's go to 7 with audio.
Effort to
this is defense
be cautious now of implicit bias when you're considering the evidence in this case. Second row.
Not nearly as
third row
fun to listen to as the prosecutor. But
now, when we were back in the jury room the last couple of days, Some of you answered some of the questions. I think I might be able to, or I believe so. And you recall that we asked you to
It's sort of a dry delivery. But that being said, we got some sound here. I think we're coming back for JOA right now. So,
okay, Madam Court Reporter, you ready? Yes. Okay, we're going to go back on the record after our lunch break in the matter of the state of Georgia versus Christopher Wolfenbarger.
She's hard of
case number
hearing.
24 SC 004201. I'll note that Mr. Wolfenbarger is in the courtroom, and before we adjourned for lunch, I had asked Mr. McDermott if you'd had a chance to discuss with your client the choice to testify or not testify, and if a decision had been made in that regard, so that I could go ahead and have a conversation with Mr. Wolfenbarger about that.
A colloquy, if you will.
And so you requested at the time to wait and let you have further conversations with your client during lunch. And so have you had a chance to have those conversations, Mr. McDermott?
Yes, ma'am.
Okay. So is now acceptable to you for me to inquire with Mr. Wolfenbarger?
Yes.
Okay. Mr. Wolfenbarger, so I'll tell you like I tell witnesses. I'm fixing to ask you a series of questions, and when you answer, I'm going to need you to answer out loud so that the court reporter can take down your response. Do you understand, sir?
I do.
Okay. So, Mr. Wolfenbarger, do you understand that you have a right to testify in this trial, and that if you want to testify, that nobody can prevent you from testifying?
I do.
Okay. And do you understand that nobody can make you testify? That is, you have a right to not testify if you don't want to.
Yes, ma'am.
Okay. And do you understand, sir, that you, not your lawyers, are the person who makes the decision whether you will testify or not testify?
Yes.
And do you also understand, sir, that if you do not testify, then upon request by you or your counsel, that I will instruct the jury that your decision not to testify cannot be used against you in their deliberations?
Okay.
Okay? So you do understand that?
I do.
Okay. And do you understand that if you choose to testify, you won't just get asked questions by your own lawyers, you will also be subject to cross-examination by the state's lawyers? Do you understand that, sir?
I do.
Okay. Now, I don't want to know what you've discussed with your attorneys, but have you had a chance to discuss with your attorney the decision whether you will testify or not testify?
I have.
Do you need any more time to talk to your lawyers about that decision?
No, ma'am.
Okay. Having had an opportunity to talk with your attorneys about that decision, do you wish to testify in this case, or do you not wish to testify?
I do not.
You do not wish to testify. Is that correct?
That's correct.
Okay. So thank you, Mr. Wolfenbarger. Based on your responses to my questions and your representations regarding having had ample time to discuss that issue with your attorneys, I find that Mr. Wolfenbarger has made a decision to not testify, and that decision has been made with an understanding of his rights, and that decision is knowing, voluntary, and intelligent. The second issue I wanted to take up with y'all is, it might not matter at this late hour, but my understanding is that the Sheriff's Department has now acknowledged that warrant and said they are taking care of it. So I don't know what that means, but it is what it is.
That's what the deputy told me as well, and it's unclear how we can kind of monitor it, but I know in the past when I try to call the warrant division, they rarely give me much information, but I take their word for it. They're working on it, and we'll either stay in touch with you or maybe the DA's office, and I can try calling the warrant division. I just know they're usually very reluctant to give information on the phone. So.
Okay, thank you. Now, the other thing I wanted to take up, I don't know how long it might take and where we are in terms of how much more time we might need with the jury today before we would be ready to for the case to be done. But we do still need to revisit the matter of the motions that the defense wanted to put on the record in terms of any motions at the close of the state's case. As we put on the record earlier, in an effort to be efficient with the jury, we went ahead and reserved your opportunity to raise those objections or those motions after we went ahead and proceeded with the state resting in front of the jury and then y'all going forward with some witnesses that you had.
Yes.
Okay.
At this time, in light of the state's having rested its case, we have moved the court for a directed verdict of not guilty on both counts. On malice murder, the state has not proven any, it has not given any evidence of a cause of death. They have not shown any evidence that Christopher caused Melissa's death. They've not shown any evidence that she died unlawfully. On felony murder, they've not given any evidence that an aggravated assault occurred. They've not given any evidence that an assault occurred. They've certainly not given any evidence that it occurred with an object that could result in serious bodily injury. And they've certainly not also given any evidence that an aggravated assault occurred that caused her death. And they've not proved the cause of death. In neither case have they proved an intent to carry out either an aggravated assault or a murder with malice aforethought. In this case, Your Honor, is the evidence of guilt is only circumstantial, and the court must rule out every reasonable hypothesis that would support his innocence. They have not ruled out the fact that other people, including the victim's parents, including the victim's uncle, Martin Eric Jackson, including any number of random people in the area, could have carried this out. There are a number of reasonable hypotheses, and we've given evidence for some of them. And the court is authorized to apply that standard in granting a directed verdict. Just a second, Your Honor, please.
Sure.
Lost his place.
The state has given some evidence from which, from what we've talked about with prior difficulties regarding the incidents of alleged domestic abuse that occurred in July of '98 and at some undetermined time before that. But when you're considering what a reasonable juror would, well, I think your jury instructions covered as well, as far as what a reasonable juror would be allowed to consider as toward the elements of the crime. They cannot consider or infer character. They may not infer from those things that he had the character to commit other such crimes or wrongs later. In other words, they can't use that as propensity evidence. So they can't say, well, he did this, he may have hit her on one other occasion, so he must have done it later, and therefore that fulfills one of the elements of the crime. They can't do that, and this court can't consider that. And as far as prior difficulties are concerned, the finder of fact is only allowed to use that to consider a state of feeling between the parties. So I would say there's abundant lack of evidence in this case of intent and of the elements of the crime, and so we would request the court grant a directed verdict at this time.
Thank you, Mr. McDermott. Who will I hear from for the state?
Me, Judge.
Mr. Fawcett,
Yes.
your response?
Your Honor, I would cite two cases as a. Then my computer goes. One second.
You're citing cases for what? It's not a motion. This is. Tell us what you told us during the trial.
Your Honor, I would cite two cases as authority for the court at the basis decision on. The first case is Odom versus Hughes. That is a Georgia Supreme Court case, 293 Georgia 447, 2013. Second case is Miller versus Lynch, 351 Georgia Appellate, 361, 2019 case. It ultimately speaks to the decision before the court when there is a conflict and when there is no conflict in the evidence that's been presented by the state. Miller states the trial court may direct a verdict only if there is no conflict in the evidence as to any material issue, and the evidence introduced with all reasonable deductions therefrom shall demand a particular verdict. Where any evidence, even slight evidence, supports the opposing party's case, the directed verdict is improper. So, first, the state is not required to prove evidence of motive, but the jury is authorized to consider evidence of motive. In this case, I would cite evidence of three different potential motives for this defendant to murder Melissa Wolfenbarger. First was the pending state court case from the July 1998 incident. There was a battery, and even though Melissa wrote an affidavit saying that she no longer wanted to pursue the TPO, we know from the March 29th, 1999 date that that criminal case was still pending. I think the fact that that case was still pending and that Melissa was murdered and was unavailable to attend, her head being found a month after that case was dismissed when they couldn't locate her, I think the fact that there was a pending case, the jury can consider that as possible motive. I think that the fact that this defendant was aware that Melissa Wolfenbarger was seeing an individual he referred to as Mike, we heard testimony from and confirmed and corroborated that. The fact that she was having an affair is another form of motive, possible motive for this defendant to murder Melissa Wolfenbarger. And we also know from Melissa's mother, the letters, and this defendant's own mouth that Melissa planned on leaving this defendant. All three of those are independent, separate, possible motives for this jury to consider as reasons why this defendant would want to have Melissa Wolfenbarger murdered. There are prior difficulties, and those prior difficulties further corroborate the battery that occurred on July 1998. There are three instances of the prior difficulties. The first in the beginning of the year, I believe it was February or March of 1998, where Tina Patton describes seeing marks around the neck of Melissa Wolfenbarger. Vividly describes that. As does the officer Marlon Sutton, describes the events that took place on July of 1998 when he, according to his report, observed bruises and abrasions on the person of Melissa Wolfenbarger. And then we have Thomas Dixon at the end of December 1998, which he's relaying information about the continual abuse that Melissa endured during that period, during that year, and also, again, how she planned on leaving him. I would say that from the testimony of the medical examiner's office, medical examiner, Dr. Terry in particular, her testimony was that she does not, in her expert opinion, believe that Melissa Wolfenbarger died of natural causes. That is from the circumstances of the facts that she reviewed, the fact that there were tool marks on the person, the bones of Melissa Wolfenbarger, on the neck, on the limbs, on the femur, the fact that the bags appeared to be situated to where she was, in her opinion, murdered at a different location, that those bags were placed there very recently to the time that they were located. Because of the rip in the bag, she isn't able to tell the time of death. You know that the head had not been outside of that bag for more than a day because there were no maggots, there were no insect activity. The doctor couldn't say whether or not the remains had been refrigerated and dropped off. That was a possibility. She also couldn't say, whether or not Melissa had been strangled because the parts of her neck were missing for her to make that determination. She couldn't say if she had been strangled. She couldn't say if she had been choked, stabbed, shot, or a number of other different manners of death were just not available for that determination because of what was missing. And I don't believe that the defendant should be able to benefit from how well he was able to dispose of her body. The statement from Dr. Terry is that the circumstances lead her to no other conclusion, that it's highly likely that she died of homicidal violence. And I think that that in and of itself are facts sufficient enough that the jury should decide this case. I would ask that the court deny the defendant's motion.
It's highly likely she was killed.
I agree with you
absolutely
regarding the murder charge, that there is evidence from which there's evidence in the record that would create issues for a jury regarding the fact that homicide occurred and the fact that Mr. Wolfenbarger may or may not have caused that homicide, which are issues for the jury. So I'm going to deny your motion on the count one for murder. I think for largely the same reasons I should refrain from granting a directed verdict on the felony murder, but I mean, candidly, I do have some concerns about the fact that even if there are clearly facts, the circumstances of her being found, right, that would support an inference, right, a reasonable inference if the jury decides to make that inference that the cause of her death was homicidal in nature. There's not any facts from which we can determine that any sort of weapon was used against her in any offensive manner. So how do I reconcile that?
Well, so it is not required for it to be a weapon. A per se weapon. So it's not required that the weapon be per se like a gun. Gun's per se weapon is by statute, but any object that has a possibility of causing serious violent injury.
Right, but there's no evidence of that. That's my point. I can infer that she was killed by homicide because of for example, a jury could infer that from the circumstances of how she was found and how her body was dismembered and disposed of. But can you also rationally infer that she must have been assaulted with an object which, when used in the manner in which it was used, is likely to result in serious physical injury or death?
Yes, you can.
Okay.
And the reason why is because if she did not die of natural causes, there is the inference that there is an intentional act by the part of this defendant to cause her death, whether that is poisoning. That would be a substance that would cause serious violent injury. The aggravated assault could be the poison itself. If it was his hands around her neck and strangling her, the hands would be an object. We typically charge fists, feet, knees, elbows. All of those objects could be offensive weapons depending on how they're used. And it could be something that is man-made, like a gun, like a knife, like a belt or rope. And the point of the charging and the way the indictment is charged is because it is because there aren't parts of her that would allow for a determination, like the torso, for instance, like the neck structure. We cannot, with any degree of medical certainty, narrow down the limitless possibilities of objects that could have been used to kill Melissa Wolfenbarger. That's why, because of the circumstances of this case, dictate that the indictment be charged in a way to allow the jury to consider all of those possibilities. And so the court is going to instruct the jury.
Well, I mean, not necessarily. The DA could have elected to just charge murder, because either you can or can't prove murder. They didn't have to charge felony murder. I mean, you said we had to allege it the way we did. That's if you chose to allege felony murder, right?
Right. Having made that decision to charge felony murder, I think that the intent was to give the jury the ability to consider all the reasonable possibilities of objects that could have been used to commit this serious violent injury on the person of Melissa Wolfenbarger. And I'm saying it's serious violent injury because it wasn't a natural death. The circumstances create really the only reasonable inference is that this was a homicide. And so I think if...
Yeah, I don't disagree with you that maybe the inference is that it was a homicide. The question is there a reasonable inference that it was an aggravated assault that caused a homicide?
And I guess what I'm saying is it is impossible for her to have been murdered with an intentional act.
Without having also had an aggravated assault.
That is correct. That's correct. I don't see a scenario where that's possible. That's why I mentioned poison. Any object that would cause the death of Melissa Wolfenbarger with an intentional act would fit the category of an offensive weapon.
Okay. Thank you. Mr. McDermott, your response, sir?
What I hear the state saying is we can't eliminate every other reasonable possibility. And in the circumstantial only case, that's the standard by which it gets judged. It has to be. You're about to read jury instructions to the jury that says if the state has not excluded every other reasonable hypothesis.
Right, but that's a decision for the jury, not for me necessarily.
No, not only. There are cases that say that standard can be used during a directed verdict. Wood v. State, more recent one, I don't know the number here, if you want to look at it. Stack-Thorpe v. State, that was a 2004 case. It was a negative case, but they upheld the same standard, that you may use that on a directed verdict. And what I hear the state arguing is they're basically confessing to you, we have not eliminated every reasonable hypothesis. We can't tell you if it was poisoning, which, by the way, is not aggravated assault by a deadly weapon. It's a whole different category that they didn't charge. And I was going to say, and the same with strangulation. It is a separate statute under the aggravated assault statute. They didn't charge that. They charged specifically offensive weapon.
Setting aside the somewhat nebulous understanding that we all have because of the circumstances of how Melissa's body was found, am I wrong that the state is allowed to prove facts that would demonstrate in any way that it might have occurred? I mean, I understand your position is they haven't offered any facts about how it might have occurred, but there are different ways that someone can be assaulted in an aggravated manner, and aren't they allowed to offer facts that would prove any way that might constitute that under the statute?
Well, I mean, they can offer whatever they want as long as the court allows it. But as far as proving what they've charged in the indictment, they have to prove an offensive weapon.
Right.
Okay. It can't be by strangulation, it can't be by poisoning, and they've not eliminated by the way that she died of a drug overdose in somebody's house and they panicked and tried to hide the body. There's a lot of possibilities they haven't tried to eliminate, and that's what I'm trying to say. This doesn't need to go before the jury. They don't have proof that an aggravated assault happened. They don't have proof of a deadly weapon. And they don't get to say, well, just let us have a smorgasbord before the jury. It's supposed to work in the opposite direction. If you charge something, you're supposed to be bound by that.
Okay. What, Mr. McDermott, you mentioned the Stack case. Can you give me that citation?
It's Stack-Thorpe, citation 270 Georgia App, 796.
Okay.
The other case is Wood v. State. It's a little older. 156 Georgia App 810.
Thank you. As I've said, I'm going to deny the motion for directed verdict on the count 1 for murder. I'm going to look at the case law, and I'm not going to rule right now on the DV on the felony murder count, which is count 2 of the indictment.
Understood.
Do we have other witnesses that we'll hear from the defense?
I have one other witness here.
Okay.
I was trying to get in touch with another one who's just not going to be available, except maybe by Zoom. Did we discuss that? I'm trying to get him.
He did. He said he would.
And then the one we're trying to arrest.
Okay, so if I tell you that we're ready to resume for the afternoon and you have your one witness when they're done and you don't have another witness, are you ready to rest? What's going to happen then, sir?
I still want that other witness here. I'm going to ask for a continuance if she's not here.
Okay. Obviously, does the state anticipate that there will be some rebuttal just from a timing perspective?
Yes, Your Honor.
Okay, like how much? Like a whole day's worth or?
No, I would say at most an hour, hour and a half.
So we're still thinking, other than perhaps this witness and the request for a continuance to find that witness or deliver that witness here, we're still thinking that today we can get the evidence closed in this case. Is that still reasonable to you, subject to this witness?
Well, I mean, assuming my witness, yeah, subject to the availability of that witness. If she were here, I would probably need an hour, maybe 45 minutes with her.
Okay. Okay. So anything else we need to take up before we bring the jury back in?
Nothing from the state, Your Honor.
Nothing from us currently.
Okay. We're ready for the jury.
Okay, so this is a tough situation. You've got the sheriff, who was the law enforcement side, on the side of the state, responsible for bringing this witness in that defense needs. And if the sheriff just doesn't get around to it, oops, we were busy. That's a tough situation. I think they should have handled this a little bit earlier, but this is Fulton County. Do we know who the witness is? Wendy Walton, Wendy W something. I don't know exactly. Subpoenaed witnesses should be held in solitary confinement until dismissed. Change my mind. Well, this one might be. Did she deny both? She denied the first. So she says there's enough inference, there's enough circumstantial evidence that the murder can go forward. But felony murder, the second charge, which has the underlying aggravated assault with a weapon, she's like, I don't know. I don't know about that one. She might before the jury gets charged or even after they come back with a verdict, strike it. That'd be interesting. He never reported her missing, went as far as claiming he saw her after she was already gone. He definitely had a motive. Let's be real, probably did. Just can't prove it. Well, or he's telling the truth, right? Or this other person she was having an affair with.
Mr. McDermott, the defense may call its next witness. The defense calls.
I'm sorry, defense calls.
That's okay.
I'm counting that one. Anything goes. Defense calls, state calls, small details.
Come on up, sir. And when you reach the witness stand, if you'll do me a favor before you sit down, turn around and face the deputy and raise your right hand. He'll swear you in.
You swear or aren't you the testimony that you're about to give?
Your Honor, I think I need to get Ms. German to admit me to the Zoom.
Ms. German or Mr. Freehoff or Ms. Johnson, can somebody admit Mr. McDermott to the Zoom?
There he is. Come on in.
I think I'm with the state and you think I'm the defendant.
Yes, exactly.
Yeah, you can all hear it.
Joseph Wolfenbarger. That's JOSEPH WOLFENBARGER.
And if you would, while you're testifying, if you'll just try to lean forward into that microphone to make sure that we can hear you, okay, sir? Thank you. Go ahead, Mr. McDermott.
Mr. Joey, do you know the defendant?
Yes.
How do you know him?
That's my father.
Okay. And do you know Melissa Wolfenbarger?
I've know of her.
Okay. And do you know Kathy Wolfenbarger?
Yes.
And how do you know her?
That's my grandmother.
And do you live with her?
Yes.
Okay. What do you do for a living?
Mechanic, for the most part.
Okay. Did you grow up with Kathy Wolfenbarger in her household?
Yes.
Okay. Do you remember at any time growing up, say around the early 2000s, that she took all the pictures of Melissa Wolfenbarger down from your house?
I don't really recall ever seeing pictures of her, like, in the house.
Okay. Do you remember at some point in your life being told what happened to your mother?
Yes. More so at a young age.
And what were you told at a young age?
I mean, I would say I was at least about 4,
okay.
5, maybe.
And what were you told about
Your
her?
Honor, I am going to object to that. That would be hearsay.
Yeah, I don't know exactly.
Sorry, I apologize, sir. When there's an objection, I have to just wait and not answer the question. Can y'all come here for a second, please?
Quick little sidebar. This is the defendant's son, Joey. Doesn't seem to be really excited about being here, but here it is. Here he is. Gonna work with the magic with the buzz. I can a little bit. It's coming from court. It's like a grounds loop issue, I think. 60 hertz. Well, it's not 60 hertz. It's lower. I need a scope so I can see what the hertz is exactly. It's in the range where voice falls quite a bit. So if I take it out, it's going to take a big part of the voice out as well. But
Mr. Wilson, the objection's overruled. Mr. McDermott, please go ahead.
I'm going to attempt to go back in, if I may.
Sure.
It might help to have the current day, right?
That would help. There's a new one every day.
Thursday, August 21st.
Yes, sir.
All right, we'll see if it works. Okay, I'll repeat the question. Do you remember what you were told happened to you?
That somebody had killed her, and that it's only so much you can tell a small child, but it was more so that it was done in a very horrific way.
Did you at some point move in with your father?
I mean, yes.
And about how old were you when that happened?
It was after high school. It was.
Okay.
Yeah, I can't recall the exact dates, but.
Do you remember where you lived at the time?
Yeah, same place he was found.
Was it?
In Griffin.
In Griffin, okay. And did anyone else live with you at the time?
Yes.
And who were they?
My little brother, Alias. And it was mainly just us 3.
Did your sister live with you at any point?
No, that was before.
Did she come visit you at any point?
At what time are you referring?
This is afterwards.
Like,
okay, let me try a different line. Do you remember at some point the defendant making a comment while watching a TV show that he knew how to dispose of a body by burying it under concrete or something to that effect?
it wasn't necessarily from a TV show. It was more so we were discussing about how Carl had gotten away with other murders, and we were talking about different scenarios, and my sister had walked in later on, kind of caught half of the conversation, and kind of been standoffish about the conversation.
Okay, so a couple questions just to clarify. The context of the discussion was Carl Patton's murder.
Right.
Okay, and at some point Chrissy walked into the room and overheard the conversation.
Yes.
Okay. Your Honor, I'd like to share screen, please.
Okay, are you in?
I am in now. What I want to share is previously discussed self-authenticating document. It's a nationally reported news article. I emailed it to you as you requested.
Y'all come in.
All right.
Sidebar. Self-authenticating document. It is a national news article. Some reporters about to go center stage on this trial. Who is Carl? Carl would be the victim's dad, who happens to be a serial killer and is passed away. Oh, thank you. The relief. It's almost like Alka-Seltzer for the ears.
Just a moment. Thank you.
All right, the jury.
You can sit there. Yes. You just stay right there.
Jury's being excused. We might get a little proffer, maybe? I think we're going to get a proffer. I wish I had water. Defendant's just rubbing it in. Mrs. Ari took a whole flat of water, like a whole case of waters with them, which is great. They're staying hydrated, but I'm thirsty. Yes, plop, plop, fizz, fizz, oh, what a relief it is. Please click the like if you can hear the buzz. Yes, just click it one time.
Outside for just a moment, please. Thank you. But don't wander far, okay?
Okay, witness is now out. We get in a little argument, maybe. In the Donna Adelson case, they are explaining concepts to the jury like this.
The state has to exclude
beyond the exclusion of reasonable doubt. Important things to know. They're still trying to whittle down the possible potential jurors to that final jury pool with the deliberating and alternate jurors. DoorDash water and Mountain Dew. I could do that. Uh-oh. Now we have nothing. We've lost all connections here. Wait for it. Tap water. Dylan Foster, I'm thirsty, not dirty.
In front of the Walmart.
Remember when Weather Watch sent RA a drink via DoorDash during the live stream? I do remember that. I'll have some by tonight. What is tap water like in the U.S.? Just chew it thoroughly and you should be fine. No problem. All right. Here we go.
Full disclosure, I did read the article at the time to assess that assertion. Mr. Fawcett, what is the state? Or Mr. Wilson, I guess technically it's his witness. What is your position? I don't really care. Let me clarify for my record. I don't really care who argues.
I sense that, Your Honor. Your Honor, that article is, we don't have any further, I agree that it's self-authenticating, but it's an article about facts of this case allegedly told by someone.
Well, let me...
That makes it for the truth of the matter asserted.
Well, forgive me for interrupting you. Mr. McDermott, what is the purpose of offering this article anyway?
Thank you for asking. The relevance of this article is that there was an audio played, an audio interview of Christopher in 2021 in his home. At one point in that interview, he's asking questions back and forth with Detective, I believe it was Sergeant Layton, and he said something about Melissa's body being found in bags. Layton jumps on that like a gotcha moment and says, I never said they were in bags. That is a point the jury could hear and presume that Christopher was asserting knowledge about how she was disposed of that he didn't have prior to that. Christopher retorts in the video, or in the audio, kind of just in passing, well, it was on the internet. And this article, that's why I had to stipulate to the date of that interview, was because this article was published in a national forum 3 days prior to that interview. And it would have been fresh in his mind. And so I think the jury, the defense certainly deserves to be able to put that before the jury to see that this was not only on the internet, it was in a prominent place, Dateline NBC. And as you can imagine, was certainly have been shared family to family and say, Chris, do you know you're in this article, etc. I'm not going to elicit all that. The point is to just say, here's a nationally reputed article, and it would have been the source of his knowledge, or it could have been the source of his knowledge as to the bodies being in bags.
Tell me again who that conversation was. We're talking about the one in 2001?
No, 2021.
2021, thank you. And that was with Calhoun?
Shepard and
Okay.
Layton.
Okay.
And it's the one where they get into this in passing. He mentions that their body was in bags. Speaking of something that happened much earlier, right? But they're like, we never told you they were in bags.
Okay. Mr. Wilson?
Your Honor, I can't see how this is the proper witness to publish an article. I think that what he said himself is that he's offering it for the effect that it had upon Christopher Wolfenbarger. Not Joey Wolfenbarger, but Christopher Wolfenbarger. I think that needs to come from the defendant, Your Honor. This is using hearsay, and to say it's not for the truth of the matter asserted, unless he has personal knowledge of the facts behind it, it absolutely is offered for the truth of the matter asserted, not what effect it had on the defendant when you're asking another person to testify as to the effect that it had upon the defendant.
Okay, well,
by showing the article.
I wouldn't let him testify about what effect it had on his father.
Okay.
Go ahead.
Well, Your Honor, showing that article is tantamount to putting it into evidence. I think he can ask if he knows. He can ask what his personal knowledge is of articles on the. But to put that article on there and that somehow give it a self-authenticating extra level of authenticity, so to speak, that's improper, Your Honor. I mean, because that's what they're doing. They're trying to bolster testimony by using a news article, which is not really how it should be done.
I also, so at the time I did review the article, and I looked at some case law, and the concern I have here is that there are ways to ask Joseph Wolfenbarger, were you aware that your mother had been found? Did you become aware that your mother had been found in bags sometime before 2021 or whatever? There are ways to establish that. There are even ways to establish that news articles that were widely available existed. But the only purpose, in fact, I mean, the only purpose to offer a news story like this, the only reason that it's self-authenticating is because the idea is that the facts in there are true and can be relied upon because they are in, widely available, reputable publication. And what I need to pull up the case law that I was looking at, because that was like a week and a half ago. I was looking at it like a week and a half ago, but ultimately my concern is that this is going to confuse things, because it is a long article with lots of detail, some of which may or may not be in front of the jury. And I would be worried about confusing the jury, when really what I understand you to be talking about is what you're trying to establish is that the fact that Melissa was dismembered and found in bags was publicly available knowledge prior to 2021. And there are other ways to do that without injecting all of this narrative information that's been wrapped up in a pretty package by Dateline NBC.
Okay. A couple of things. I just want to backtrack to what you said about self-authenticating and the purpose of it being that the facts in there are true. That's not an authentication question.
I understand it's not an authentication question.
The self-authenticating just goes to, is the source what it claims to be?
I understand, but
we're not entering any true facts. Now, as far as the whole article coming in, I began this discussion several days ago with Mr. Fawcett. I shared with him the link, and I said I don't want to put the whole article in. I just want to have a screenshot of the one paragraph that says the body bags. And of course, this discussion has drug in the course of trial. You know how things go. I haven't gotten a ruling back and all that stuff. So my intention is not to put all these facts before the jury. It's just that one, and that's why along with the link, I sent a screenshot of just the beginning of the article that has nothing more than introductory material and one paragraph that mentions the bags. That screenshot also has the date on there, so I can ask him what date was this published.
Well, that's exactly why it shouldn't be let in, because he's using that to supplement questions that can be asked of this witness.
I'm sorry, say that again, Mr. Wilson?
Well, he's using the date, for example, the date of the article. He can certainly, as the court has already said, he can ask questions. Are you aware of these articles? Are you aware of these things? Rather than putting in an article itself.
So if I understood your Honor, that you would have a problem with confusing the jury, I think providing just a short screenshot of only the relevant information solves the 403 problem.
Sunkist, I think you might be using a word that's on the banned list on your question, because I'm not seeing it in the feed, and the mods have not deleted it.
Sorry, I'm trying to find my prior research, and for some reason, the Westlaw is not cooperating with me, so just give me a moment.
I don't think this is true. Oh, but maybe it was.
Okay.
They're arguing over whether an article can come in.
So I want to take a look at that, Mr. McDermott. What were you saying, sir? I was trying to look at Westlaw and pull up my prior research.
My apologies for interrupting. I was just appending on to what we had discussed, that you had discussed the problem of confusing the jury with facts that may not be in evidence, and I think providing only the screenshot with the one paragraph and the relevant information solves that 403 problem, so there's no confusion.
Well, I mean, the screenshot that you've provided says that Mr. Wolfenbarger was arrested on August the 7th. It says he's currently in custody. It says, it tells a story about Christina when she was 3 years old, that I don't recall her testifying to. I mean, I'm looking at the screenshot that you attached to your email.
Yeah, I'm a little, don't remember those being on there.
Get better at screenshotting.
Can I approach, Your Honor?
Well, I'm going to share my screen so you can see what I'm talking about.
Okay.
So this
may have gotten an earlier version of the screenshot.
Okay, well, the email that you sent me at the end of our pretrial conference on
that's right, the update.
last Monday
Yeah.
That's the screenshot that you sent me, and it has lots of information that is not in evidence and or inadmissible.
That is true.
That is true.
Could I just redact that and leave what's below?
So, again, I don't understand why you need this news article to establish the fact you're trying to establish, which is that at least as of May of, does that say 2001?
Yes.
Okay.
2021.
2021, because...
And so the point I keep trying to make is that this was published 3 days, literally, before they went down and interviewed him on this point.
I understand that. But also, couldn't you have established that with Calhoun? Or Shepard?
I didn't interview Shepard, and yeah, it could have been.
I just mean, there are other witnesses in the case who could... Okay. Here's the... Yes, sir.
I don't want to hold up the court any further. If you want to rule against it, so be it, and we'll move forward. But it's authentic.
No question it's authentic, but it still has to be relevant and non-prejudicial, and
it is relevant, but it's prejudicial. I understand that.
And not hearsay or subject to an exception. And just because it can be authenticated doesn't make it not hearsay. And what I'm primarily concerned about is that it has minimal relevance for the concern. I think that the prejudicial nature of the facts that are contained in here, which are either not in evidence or would be subject to some sort of limit. I mean, like I said, I related the stuff that was there, but even if you were to limit further what it shows, what I think I understand is that the purpose of this article is simply to demonstrate that in 3 days before the police talked to Mr. Wolfenbarger in 2021, there was a news article that said that she was found in bags. And there are other better ways that are less inflammatory and prejudicial than this narrative that's been put together and made all shiny and pretty by Dateline NBC. Okay.
Joey's out in the hall.
Anything else that we need to, and just to be clear, I understand I didn't give you a ruling, but I need y'all to let me know again when you need a ruling, right? Like that was 2 weeks ago. So, or, you know, so.
In all fairness, I definitely tried to make that happen.
Well, I mean, you sent me an email, I understand that, but I've asked any number of times what other matters the parties need me to take up, and at no point did somebody say, oh yeah, there's this news article I want to ask Joey Wolfenbarger about, and you haven't ruled on that, Judge. Nor, in fairness, did the state say, hey, Mr. McDermott wants to offer this news article that we object to. Nobody brought that to my attention, so I apologize that we had to do it on the fly with the jury stepping out, but there's a reason I asked 87 times, is there anything else that y'all want me to address before we do whatever we're doing?
Understood.
Okay, thank you.
We thought that was rhetorical,
so are we ready for the jury to come back? Mr. Wilson?
Yes.
Mr. McDermott?
Let me ask one more question.
Yes.
I don't have any other questions for this witness except one. I was going to take a previously admitted exhibit, the weather reports, and see if he would be able to read that for the jury. It's perfectly common sense. Any average person should be able to do it. And the detective, it's to impeach the detective who sat there and hemmed and hawed and made a big deal about it.
Isn't that document in evidence?
Yes.
So the jury can see it.
Right.
Can they not?
So include in your closing
and if it's
argument.
common sense, won't they be able to figure that out?
So you're saying no do it?
I mean, I just don't know any, I mean, other than that if it's common sense, your average person should be able to read it. But if I recall correctly, the detective struggled a little bit to read it too. And so I'm not sure I understand why Mr. Wolfenbarger, hang on. I'm not quite sure I understand why Mr. Wolfenbarger would be able to understand it and relate that either. Joey Wolfenbarger.
I think that's the point. I think the detective was being dishonest. And I think if an average Joe mechanic can read it, it would impeach the detective's credibility.
Average Joe mechanic. Wow.
Mr. Wilson, that noise you just made is not an objection.
I understand, Your Honor. Your Honor, I do object to that. I don't think. I think it's been put into evidence. It's already been questioned about, and I think it's been to have a witness read it when the jury can read it is cumulative, repetitive, and argumentative, Your Honor. So I think it's not I don't think it would be appropriate for him to do it with his witness in front. I mean, obviously the person he did cross was Detective Callan.
Okay. I feel like you've made that document's in evidence, and you can argue that to the jury, and you don't need to inquire with Mr. Wolfenbarger about it, Mr. McDermott.
Fair enough. So, bring it
Anything
back in
else?
here. I will say no more questions.
Okay. Could you get Mr. Joseph Wolfenbarger back for me, sir? Thank you. Deputy, we're ready for the jury again.
I think defense gives up too
Obviously,
easily.
once we get Mr. Wolfenbarger back on the stand. Thank you, sir. Sorry for that delay. Come on back. And you can just come on back and have a seat on the witness stand. And Deputy, now we're ready for the jury.
And Deputy, while you're at it, if you can get that other witness in here, that would be great. That noise you made was not an objection. Yeah, let's do another anything goes. Only... This is wild. Yeah, I think defense gives up too easily. They need to assert themselves and say, this is what we're asking. You know, what's the phrase? We're mad as heck and not going to take it anymore or something. Just stand up. Average Joe mechanic gives the weather. Likelihood that our missing witnesses here, I would say slim to none.
Thank you all. Please be seated. Mr. McDermott, you may resume your examination.
Thank you, Your Honor. No further questions for this witness.
Thank you, sir. Mr. Wilson, questions for this witness?
Yes. Thank you, Your Honor. Now, you were born on July 5th of 1996, isn't that right?
Yes, that's right.
So you would have been about two and a half when your mother went missing, correct?
That sounds about right.
And you have no personal memory of that, correct?
Not of her, no.
So you have no memory at all of your mother?
I mean, no, not like a living version of her, no. I mean, there's little bits here and there I can remember, like, of, you know, the ceremony, but that was it, really. I didn't really understand, you know, who she was, you know.
Yeah, because you were only 2.5 when it happened.
Right. I mean, but it was later on, when the ceremony and whatnot.
Now you lived with your mother. Well, excuse me. You never lived with your mother.
No, not really. No.
Yes, you lived with Kathy Wolfenbarger, your grandma.
Right.
She wanted you to call her mom?
Not exactly. It was just more so it was easier that way.
So you did call her mom?
Yes.
Okay. And you never saw pictures of your mom at all while you were growing up?
I mean, I've seen some, but they wasn't like displayed all over. You know, there was, you know, the rare occasion that we would go through photo albums or whatnot, but, you know, that's the only real time that I've seen them early on.
And those photo albums were located in the house, correct?
Yes.
Okay. And you were 4 when you were told that your mom had been murdered?
I would say that's about right. 4 or 5, somewhere around there.
And you were told by Kathy Wolfenbarger, correct?
Not really. I mean, it was more so of Rachel. Like she got more into detail with it.
Okay.
You know what I mean?
And so you heard a bunch of details.
Yes.
When you were 4.
Yes.
And you never asked your dad about what happened, correct?
I mean, it'd always been a touchy subject for, you know, talk about with anybody, you know, it's not really.
Okay. So you never had conversations about your mom's death with your dad, haven't you?
I mean, bits and pieces, you know.
But nothing extensive.
Right.
And that over the years?
Right.
Okay. And after high school, you moved in with your dad?
Yes.
And you haven't had conversations with him about it? Only bits and pieces, correct?
Correct.
Okay. And you were still living with him? You're still living at that address?
I mean, not at the moment, but, you know, I was off and on for a while, you know, shared 2 residents.
Who was the other residence was Kathy Wolfenbarger?
Yes.
Okay. Can I just have a moment?
Sure.
Right now, you live with Kathy?
Yes.
Okay. And who is Rachel?
That was the woman he got with after my mom.
Okay.
That's who Rachel is.
So you've talked about it with your dad's girl, kind of living?
Right. They were living together and they moved in across the street.
Okay.
Yeah.
One more moment.
Sure.
Thank you.
Maybe Rachel is the, no, it's a Wendy we're looking for, right? It's a Wendy.
What year were you born again?
96.
96. So when Melissa's remains, or when you went to the ceremony, you mentioned the ceremony a while ago, and you said you had just faint memories from the ceremony. And that would have been in 2003, correct?
Yes.
And so you would have been about 6 or 7 at that point. What have you been 6?
Yeah, give or take, yes, about
Okay.
6.
So you wouldn't have heard anything about your mother's, how she went missing until after that point, correct?
Yes.
Okay. And is your memory still fuzzy from all that stuff?
Right.
Okay.
Like I can remember like bits and pieces, like kind of where we were standing or whatnot, but you know, just.
And so is it safe to say that the discussions you had with Rachel would have come after that point?
Right.
Okay. No further questions.
Thank you. Anything else, Mr. Wilson?
Just very briefly.
Sure.
Now you have a full sister, correct?
Can you?
You have a full sister. You have a sister.
Yes.
And what's your age difference
10 months.
between you and Chrissy?
Yes. 10 months.
Okay. Nothing further.
Mr. McDermott?
I'm nothing further. You may be excused.
Thank you, sir. You can step down and you are excused as a witness. Mr. McDermott, defense may call its next witness.
So, may we approach, Your Honor?
Yes.
The approach right here is, Your Honor, can you call the sheriff for us? Because we don't know where our witness is. Obviously, the judge wants to move things along and say, sorry, it's your job to get the witness here, and if they're not here, it is what it is. But where's Wendy? This witness, if she does grant a continuance and say, okay, I'll leave you till tomorrow morning, which I don't think she wants to do, the witness, if located, would spend the night in jail. They would not release her. They'd hold her until until she testifies and faces the judge, possibly separately, as we've seen in other trials, about why didn't you show up when you were subpoenaed to court? I don't care if you want to be here or not. You have to be here. Bring your toothbrush. I guess we could look at the records here in Georgia and see if there's an arrest. I don't think they would book her. I think they'd bring her straight to court, though. Look for any Wendy's that were arrested in Fulton County today. Let's see if that was her.
Minutes. We're getting your steps in today. Thank you very much.
The judge sheds her cape periodically, much like a caterpillar sheds its cocoon, and she emerges as a bigger, better, stronger version of herself. It's probably hot. That's what I'm thinking. She's had a fan occasionally. The arrest was made in another shot. We did watch a witness get arrested and hauled into court, and I think held in jail. I don't think.
Thank you. You may be seated. The jury's clear. Deputy, can you do me a favor and check on the status of efforts to locate that witness or bring that witness here, because that's the next witness they want.
I will have to go upstairs because I don't have the number.
Okay. I'm gonna, because it's time sensitive, is it okay? I'm gonna ask that we leave that deputy here and you go take care of that while I take up some other matters with these individuals.
He will have to go.
So if he goes, then I can't take up these other matters with these lawyers because he's not here.
Yes, Your Honor.
Miss German?
Miss German, can you get us another deputy?
Can you get another deputy in here?
We need another deputy.
Because if you leave, then
I see my problem.
Thank you.
Your Honor,
yes, sir.
I'm curious about the rebuttal. I just want to make sure the rebuttal rebuts something that occurred today, because we didn't have a case yesterday, so the rebuttal has to be something in response to something that happened today.
Obviously.
And I'm curious. I don't think they have to pre-clear it, but I guess I'm preemptively filing a motion that they don't get to just start putting up new witnesses or dealing with issues that came up yesterday or last week, or it has to be rebuttal of today, because we didn't have a case before today.
I think we all know that that's what rebuttal's supposed to be. It is. Okay. What, though, of our other witness? They're not here yet. Mr. McDermott or Mr. Samuel, can one of you tell me who that witness is? Because I'm having the deputy check. Now, by some miracle...
Someone is coming to believe me.
Thank you, sir. By some miracle, maybe he goes upstairs and finds out that that person is already in a sheriff's car and is on the way here from wherever it was that I saw that they were from, which was, yeah, far away. No, it was, I thought it was out the west side toward Alabama.
From the state line?
It's Covington? Okay, so east side. Okay. But that's far. In any event, so let's say by some miracle that person is somehow going to be produced here today. But it's very likely that that person is not going to be produced here in any reasonable time to be testifying today. And so my understanding from you, Mr. McDermott, is that it would be that y'all would be
asking for a
moving for a continuance. Is that correct?
Yes, Your Honor.
Tell me who this witness is and why you believe that a continuance would be justified to allow that witness to testify.
So, one of the undercurrents in this trial has been the relationship between Melissa and Christopher's family, Melissa and her family. A huge part of that is this custody battle, and I think the jury's going to have to decide at some point. One side was pressuring her to do this, and one side she wanted to be with, or maybe there's some other complex dynamics. In my opening statement, I gave, basically said that the evidence is going to show that there's strong evidence of a very poor relationship between Melissa and her mother at the early stages of her life that ended up leading to her running away. Okay. The state has been able to counter that by presenting these evidence of these cards and the letter, et cetera, et cetera. Mm-hmm. But I have relied upon this witness to provide the evidence I need to sustain what I told the jury was going to show. And I think it's a relatively important piece of evidence to show that she did have a poor relationship with her mother. And so this witness was a next door neighbor to the Wolfenbarger, or to the Pattons.
To the Pattons.
At sometime in the 80s up until maybe the early 90s. She was best friends with Melissa. She is going to testify that all the things I said in my opening, including some that are arguably worse, that they were locked in their rooms, they were not allowed to leave to get water. Melissa was not happy. Melissa began running away with her. Eventually, on at least one occasion, did drugs with her and got into some other things. And she's going to testify that the locking in the rooms specifically went on from about age 7 until about age 12, every day that she came over there, all day. And there's a considerable amount more of a backstory to that. So, And then at some point after the finding of the baby, Melissa started running away.
Well, that's in evidence. I mean, that part very clearly is in evidence. I've heard people discuss it multiple times, and not just through lawyer questions.
I don't need her to establish that point, but it does establish it in the context of the timeline of what she calls Melissa's neglect and abuse. She will also testify that there were times that at some point her mother would not allow her to have makeup. She had to use colored pencils on her eyes. She's going to testify that her mother would not give her feminine hygiene products, that she had to use socks for pads. And I think those are all relevant as far as illustrating the relationship and the feelings Melissa would have had to her mother. I cannot fulfill what I said in opening statement without this witness. And so I think for that reason alone, not to mention the extremity of what she's going to testify to, I think it warrants a continuance if we need to have it.
You overpromised.
Do we have any information about why she's not here?
I do. So when I initially contacted her probably 2 weeks ago, I was actually shocked that I finally got through to her, and she was effusive to me. She was like, I want to tell my side of the story. I want to tell this. She's very clear she's not a fan of Chris, and she's not on his side in this trial. But that she said, I will show up and tell the truth. I said, well, would you testify? She said, for him, no, but I will tell the truth. And I said, if I subpoena you, will you come? She said, yes. And she, on a couple of occasions, kind of went silent as I was trying to communicate to her what days to be here. But she came back a couple evenings ago and told me that because I think it was her stepson died at the beginning of July, she's been dealing with depression and things like that, and that she just needed to spend a day or two in bed. But she texted with me. She sent me a bunch of pictures of Melissa and them growing up. She was very open about it. I shared with her that, if cost is a problem, we're allowed to reimburse you for certain things, travel, whatnot. And she said, oh, okay, fine. And it was clear to me at that point she was going to come. And then yesterday, she didn't come. And then I contacted her last night, and she gave me a hard, I'm trying not to use the words she used, but it was basically
not just no, but
I think she, yeah.
Heck
I
no.
think she's realized that what she has to testify to will help Chris in some way, and so now she's refusing to come. And I did not tell her I was going to send a deputy because I don't want her to run and hide somewhere.
Now she knows if she's watching.
That's the long and short of it. So the short story is that it was not until the day, or I think it was early this morning, that I got text from her saying I'm absolutely not coming, and variations of that.
Okay.
I want to see the variations.
Realistically speaking, though, I mean, let's play this out logically. Are we confident that even if a deputy did go to her house and force her to come here, that she would willingly testify? I mean,
I fully expect she's going to be resistant, and I would ask to treat her as an adverse witness. I have our conversation recorded, and I've made a transcript of it. So I am prepared.
Well, if she's refused to, she wasn't.
She wasn't under oath.
I mean, she isn't available if she's refusing. But anyway, what are your thoughts, Ms. Hilton, or somebody from the state?
I'll just add, if the state will waive cross, we'll be happy playing portions of the audio.
That won't happen.
That won't happen.
She said that won't happen.
Your Honor, we don't necessarily object to a continuance if this witness is under subpoena and can get here. So we're not opposed to the continuance, Your Honor. We would ask if we can have a copy. At this juncture, can we have a copy of the recording and the transcripts of this witness's interview so that we can prepare? So that's
it
what
was sent 2 days ago, Your Honor. They have the email.
Oh.
You mean you emailed them the audio file?
Yes.
Thank you. Okay, so
check your spam folder, says Greeters.
One other question that I had asked counsel at the bench, I mean, it's less than ideal, but if there is a chance, which I'm going to wait and see what I can hear from the state, from the sheriff's office about any progress that's been made to locate this person and go get her. But if there is rebuttal, is it possible we could just go ahead with rebuttal and come back to this witness if we can get her here later today?
I would not prefer that because I don't know what she's going to say, and my rebuttal witnesses may need to address what she's going to say, and so I wouldn't want to start any of my witnesses.
In fairness, Mr. Wolfenbarger did pretty much tell you what he was going to. I mean, it sounds as if the only knowledge that she could have if she knew Melissa when she was a kid is Melissa didn't get along with her parents and some specific facts about it.
But we never know what's actually going to come out on the stand. So we understand the recording, we understand what his proffer is, but I don't know what she's actually going to say, what's actually going to come before this jury. And so the state would prefer to have the defense finish their case, and then the state moves forward with rebuttal at the conclusion of their case.
Okay. Yes, Mr. McDermott.
Yes, Your Honor. Your patience is unlimited and admirable, and
she says don't
there's
try
no
me.
reason they couldn't go ahead with the rebuttal witness, and if our witness is here or not, we can still hold her over to the next day. I mean, I'm saying we can still do the rebuttal.
Rebuttal out of order?
Yeah, I think I know everything I need to know except for
where is she?
What effort, if any, has actually been made to go and find that person. So at this point, we're just going to have to let the jury cool their heels for a minute until I step off the bench so that Deputy Holt can go check, because for some reason there's not two departments that do that, right? Poor Miss Deputy Holt is stuck doing it himself, even though he's also got to be in here doing this part of the job. So in any event, I'm going to take a break for a moment so that Deputy Holt can step out and see what the answer is about this witness. And then I will come back and we will figure out what to do. I will tell you that I don't love the idea of a continuance, but if there's some reason to believe that she can be gone and gotten, and all I need to do is delay until perhaps in the morning, that's not unreasonable. But this case is going to the jury tomorrow. I mean, I just don't see a universe in which we can justify for what sounds to me like relatively narrow topic of inquiry for a witness, delaying this jury beyond having the case tomorrow. But I might consider a continuance tomorrow if there's some reason to believe that she might be gotten and delivered here and cooperative. So anyway, I'm going to step off at 3 o'clock. I'll come back in maybe 10 minutes when hopefully Deputy Holt has some information for me. Thank you.
Deputy Holt, go to work. Go to work. Wild. So I love getting to hear all this. I'm so glad this isn't just happened on a sidebar. But I'm surprised the defense, especially if the sheriff's made no effort to go and get their witness. I'm surprised the defense doesn't raise this and say, Your Honor, the sheriff is law enforcement. The prosecutor is law enforcement. They are basically an adverse party to my client's interests in this case. And their failure to act is harming my client. Meaning he does not get due process because the sheriff, puts it at the bottom of the list. Sorry, we had a lot of calls. Sorry, we're short-staffed today. All right. I don't know. Do you see that as a problem? You can't. I don't want defense to have their own law enforcement group to go out and go round people up. A kidnap squad for witnesses, but I do see that there could be a perceived conflict of interest, and let me just say it. This is Fulton County, right? This is worse things have happened here than that. Active defense squad. We're counting that as another anything goes. I know I've counted a couple during that argument, but it's worth adding one more to the list. What more do you need to see? Hilarious moment as we hear that the defense lawyer, in conversing with Wendy, the missing witness, right, who he didn't give her name, even though the judge said, "Who is this? Who is it? Give me your name." He didn't. We know who it is. Mods know. We know. We're not putting it in the chat right now. But Wendy is on the phone with the defense lawyer, and he's recording it. And Georgia is a one-party consent state. What that means is, as long as one person in the conversation, in the back, the back and forth, agrees to the recording, you can record. So it's legal for him to do it. He does have a legal recording, but she's not under oath on the phone. It's just like, hey, let's just go over. Tell me what you saw, type thing. And so it's an unsworn statement, but it's an unavailable witness. And the judge is weighing this, being like, I don't know. You can't have a witness. How do you tell the jury you should believe everything you hear in this statement if the person who gave the statement didn't swear that it's true? I mean, I don't know. How do you play that and admit that as evidence when it's not sworn? So I don't think that the recording's coming in for that reason, because it's not sworn.
You don't put a diplomatic plate on a hoopty.
You don't put a diplomatic plate on a hoopty. Crazy. Only in Fulton County. And here's what we know as well. Tomorrow, this goes to the jury, and tomorrow, Donna Adelson starts. So we're going to have podcast tonight. No interruption.
Now I'm trying to have court. You don't raise your voice again.
Oh, sorry. You guys are having fun with that one.
Bring the jury.
We have a Friday verdict watch and Friday openings for Donna Adelson, and probably beginning of testimony. We'll probably get a couple of witnesses deep, potentially one or two witnesses deep in Donna Adelson tomorrow, which will just mean an amazing weekend. Maybe we'll have to do a rare Saturday stream to catch up on anything that happens in this one, because we do have to start with Donna Adelson. And trust me, you're going to want to follow Donna Adelson. As vested as we are in this one, even if we bail on verdict watch to listen to Donna Adelson, you guys are you're going to love that case. I think you're going to love listening to it. I think you're going to like some of the players. You're going to like the chess that goes on in the courtroom, arguing the facts, digging into the history, the family dynamics, who's throwing who under the bus. It's going to be good. I was shocked. I got yelled at in my headphones. Hey, hush. All right. Jolene says, what is that from? The hush one? We just got that this morning from Judge Clark out of, I think he's in the panhandle of...
I was kicked back, taking it easy.
I think he's in the panhandle of Florida. Is that right? Judge Clark? It's always Zoom court. Just hope the judge's mic is better. I think the audio is really good in Donna Adelson. It's going to be great. So down for a Saturday catch-up.
I was told counsel wanted to see me at sidebar.
Sidebar is working. That's always nice.
Hush! Now I'm trying to have court. You don't raise your voice again.
That's such a good soundbite.
I don't like podiums, Your Honor.
That's so good. All right. May have to play catch-up tomorrow. A replay on Saturday.
I saw a chicken fight.
I'm not a camel.
Let's see if we come back to court here in just a minute.
Hear ye, hear ye, hear ye.
Ooh, that was loud. I suspect that the cameraman in the Georgia court, for one reason or another,
just sent me a video of roaches fighting.
Is running a component, some part, probably the camera itself, on a battery. And he's swapping batteries.
Apocalypse may be upon us.
Because we keep losing a feed every once in a while and then waiting for it to come back on. And it's a complete clean drop. So I think it's a battery issue. That's why you usually run the pool camera based on AC power with the battery backup. That's my recommendation. All right. Hoopty, an old hoopty. That was from just the other day with Mr. Magoo up in Judge Cedric Simpson's court.
I think I'm about to catch a whooping. I'm not a camel.
Greeners, that was a bit of a stretch there, but I'll give you a slow clap. Because you got there. A reminder, now's a good time to do this. Tonight we have a podcast right here on this channel. It is the Not Relevant Podcast. We're going to talk about some fun things, some crazy stories in the news. And I should sell sound bites. They're free. Help yourself. The stories we're following are...
I'm not a cat.
some are fun, some are interesting, some are just wild and crazy, ripped from the headlines, keep you updated on the wild and wonderful things that are happening around the world. So please
taking it easy.
do join us for that. Can I just show you something? Hang on. Where's has to go here. I'm not sure if I can. The Rodecaster Pro 2 podcast production console, which is the upgrade to this unit that I have right here, just went $85 cheaper. Woot! That's pretty cool. Let's see. I was trying to go over here. They're still picking a jury.
You're talking about stuff that is not relevant.
Hush.
Not back yet. Hush.
Now I'm trying to have court. Don't raise your voice again.
I'm sorry. Hush.
How does he do that?
Yeah, it's on sale. So think of the money I'm saving. $85. And it comes with a free 2-year warranty. The reason I like the new model, first of all, it's easier to scroll between pages of sound bites. So that helps. But the new model, and I love this. I love this about companies that release a product and then make the product better over time. So you buy it. It's like buying a car, and you're like, hey, this car will do, go 100 miles an hour, and it can go 40 miles on a gallon of gas. And then 6 months later, the company's like, hey, guess what? We're pushing an update to your car. It's now going to go 300 miles an hour, and it will go 80 miles on a gallon of gas. No charge. It's obviously, I don't want to go 300 miles an hour. You shouldn't. No, none of you should. But Rode and Blackmagic Design are two companies that do that. They'll release a product and it's great. I'm like, I love it. For the price point, this is perfect. I'm a happy customer. And then they're going to sit there and say, you know what? We figured out a way to make it better, and we're going to just make it better. Just plug it in, update the firmware for free, and you'll have a better piece of equipment. And Rode just did that with this new podcast production console.
Subject matter jurisdiction.
It allows you and somebody else who has the same device, the podcast Rodecaster 2, to make a direct connection audio-wise.
Consent to that name.
So it's not a phone call. It's not like Zoom audio. It's not through StreamYard. As clear as you hear my voice, you would hear, say, Thomas's voice. Weather Watch. I mean, it's already good. He's already on some good equipment. But the ability to bring somebody in and have their voice that I could control here and shape.
Don't put a diplomatic plate on a hoopty.
It's not a hoopty by any means. It's a nice soundboard. What judge said hush? Love that one. Jen, then that was this morning. That was Judge Clark. How do we follow Thomas's page? That's a great question for the podcast.
I'm not going to argue about semantics.
We can post it. We can post it here. There's a link to it. There's also a link to some Weather Watch gear, which I'm a big fan of. If you don't have a Weather Watch shirt and you like Thomas, you should get one. Let's see. Still waiting to come back here. Oh, I don't want to miss what happens with, Deputy Holt, to see what the scoop is on this witness. I can't follow Tech Talk, but hurrah! Yes, it's a big hurrah. Purple Coconut. It's What do you like doing, Purple Coconut? I will make you a custom analogy. You just tell me what you like doing, what you would understand. And I will customize an analogy. What is the equipment again? The Rodecaster Pro 2, made by Rode, R-O-D-E. It's an Australian microphone company, and they're absolutely phenomenal. They make the mic that I'm talking on right here. They make the soundboard I use. They make some of my wireless mics. A few items. Some of my shotgun mics.
Don't miss the forest for the trees.
I can give you a link, actually. Hang on one second. I'll give you a link so you can look at it, if you're actually interested. Just 1 second. Wait for it. Okay, making sure I'm giving you the one from the Road store itself. All right. Just posted. It is an affiliate link. Guess it's $800. No. Sweetwater has it for $618. Amazon has it for as low as $598. So Amazon's got a little bit better price on it, which is a pretty dang good deal. Used to be about $630 or so, or $700. So great equipment. It is. Here's what I love about the Rode soundboards. They are so user-friendly that their instruction manual is basically a poster board, and it is just like it's self-explanatory. And I mean that in a way that somebody who doesn't understand tech can look at the picture and be like, "Oh, that makes sense." They're color-coded, they're bright, it's intuitive, I think is the word I'm looking for, and at the same time, the output, the performance, the audio quality you get. I mean, you guys know this is radio quality audio that you get from that device. So it's I'm a big fan. I love a company that makes a really good product and then makes it better for free. All right, can I buy someone to do my household work so I can watch court? I could get you a link for that too, but not safe for work. I don't know. Don't know if we can rent a cleaner. It's big. I need to work on this one. I could never get the soundbite to work. I think I have to re-record it. I have the bigger soundbite.
It's bigger than you. It's bigger than me. It's bigger than all of us.
Sweetwater does send candy. Amazon does not. Amazon, you'll have like a 90-day return policy if you didn't open it. Sweetwater has a 2-year warranty that's free. So, still waiting for my shipment from Sweetwater. All right. Anyway, the thing I like about the Rodecaster, both the original one that I have and the replacement, they are probably the best podcasting equipment you can find. So if you want to do an audio podcast, hands down, the Rodecaster is your way to go. Every other tool out there is either trying to copy what Rodecaster has done and does it less well, or requires you to have multiple pieces of hardware, a lengthier process. The Rodecaster is entirely self-contained. It can record the podcast in a format that's ready to upload. Yeah, so if you're into doing a podcast or want to start a podcast and have a little bit of money, Less Gooder. I thought Less Well was better than worry about you getting dehydrated. I'm worried about getting dehydrated. Radio quality, AM, FM, single sideband ham. I would go with FM stereo on that one. Should check the DA's office for Wendy. She being hidden there. The judge hasn't ruled on the whether the recording comes in, but possibly the recording comes in. And if it does, let me just say, I think Wendy's got a mouth on her. I'm going to put that out there. I think Wendy has a mouth. You might hear some Southern words that you haven't heard in court before, which would be epic. You might hear him if she shows up anyway. She is, after all, adverse witness. Bet she's a hoot. Yeah. Anthony, no worries. I'll answer any questions I can. You have the Rode mic too? I do. I have the cheaper one, the $99 one, which is called the Pod Mic. They do make a couple versions. There's one that's twice this price and has both XLR plugs, which is this one you see on the back, like the 3-prong round circle. That's a professional, and it also has USB. So if you want to use that straight into a computer, that's an option. Let's see. See Mod Chat for fun fact, brought to you by Greeners. This is going to be good. I know it. Probably something I can't share as well. Let's see.
Scratch all that. Oh, that was terrible. I apologize.
What? Who is this? I don't know who that is. It is something I can share, I think. The Chuck E. Cheese case, was that when they arrested Chuck E. Cheese in costume for identity theft or something like that?
There's nothing in the order that restrains you from talking to cats.
Judge Everett is the judge on the Chuck E. Cheese case. Who is Judge Everett? Why can I not remember who that is? Oh, the judge on Adelson. Adelson is the same judge. The big guy. That's going to be awesome. All right, same judge as in Adelson. Charles Entertainment Cheese. That's him. Chuck E. Cheese. Red Pen, thanks for all your help today. Amazing. I know you've been putting in long hours with a lot of demands on your time, as has Samantha, as has Amber. Appreciate all of you. Thank you very much for what you're able to give. The channel is greatly better, more gooder. Red Pen, just for you. It's more gooder because of your efforts. So I appreciate that. Greeners apologizes too. So, Red needs a raise already. Yeah, they all do. Where's Amber today? Amber's right here. She texted right below you. So Chuck E. Cheese's case will be stalled for Donna's trial. It's going to be put off. A little continuance. Judge needs to rule on count 2 as well. I can see her going all the way to... Oh, I've got a landline call. Hang on, who is it? 800 serve. They hung up. I can see her going all the way and letting the jury return a verdict before she rules on that. It is not FedEx calling. FedEx has not done anything. Paula Mack. Oh, man. Listening to HIPAA annual training. Are you sure Wendy isn't the same one who was also dismembered in the last case? Positive. Positive. This is a different one. For sure. I like your picture, though. Oh, my goodness. I just realized what was happening in there. Thanks. Jip V? Is it Jip V? Is that how that's said? Your profile picture is great. RA has a landline. I do. It's Mrs. RA's. It's the only way I can reach her. She does not have a cell phone. Did RA ever get Mrs. RA a phone? No. I would do it in a heartbeat. I would do it today. I would kill the live stream and go out and get one, but she wouldn't carry it. I wouldn't charge it. I wouldn't use it. Aaron Blackman says, RA, is Wendy Adelson completely safe from charges? No, I don't think she is. As a matter of fact, I would not be surprised if she is charged at the conclusion of this case. I think it's actually quite likely. I think not getting your wife a cell phone is on the wheel of violence. If I get her a cell phone, there will be a wheel of violence, but I'll be on the recipient end. Do any of RA's children have phones? 3 of them. 3 of them have phones, and 3 do not. As a matter of fact, that's how I get a hold of her if I need to, because 2 of them that have phones are with her, so I just call one of the kids. Because they answer their phone. It doesn't matter who it is. They will answer. They don't get calls very often. This is a long 10 minutes. I'm worried that they're still trying to find a deputy to do something. She's considered an unindicted co-conspirator at this point. James says, my wife complains that I should not have got her a cell phone. I'll tell you this. Remember when cell phones, they did this trend, right? When cell phones first came out and you had to have the bag over your shoulder. I wasn't that early of an adopter. My first phone was the brick, right? It looked like a brick. That was my very first phone. And I quickly upgraded. I don't know how long I had it, maybe a month or two. But there was problems with that phone, and so I traded it in and got another phone that was probably about the same size as this telephone, but it had a big antenna out the side. And it also wouldn't fit in your back pocket. So I had that phone for a while I was running a painting business. And then from then on, with each phone I got, they would get smaller and smaller. And there was a point where I got a little tiny phone that is smaller than, like it's smaller than the mouse. It's just a little, hello, this little dainty thing. Battery lasted forever. It literally, it would go and go and go. But that was like the peak of the miniaturization period. And then we got we can use phones for the internet. And then they started being, the screen has to be bigger. And so they started growing again. And now, pretty soon, it's just going to be, you buy an iPad.
Hush! Now I'm trying to have court. You don't raise your voice.
I'm sorry. I was just telling a story. You buy an iPad and then carry it around in your pocket, and that's your phone. You just press it up against your face and talk. Did you use a Viper? Why does that sound so familiar?
I think I'm about to catch a whooping.
Like, I never had a BlackBerry.
I'm not a cat.
Oh man, I want to jump down here just for a quick moment.
Consider a person's character, and then as to whether I believe them or not believe them.
So in the context of, you're going to hear from some witnesses who've been convicted of felonies, who live a different lifestyle from you, that kind of thing, is that the discussion where you were having that thought?
I try to be open-minded, and I think there are all kinds of people, not everyone, so I don't want to prejudge a person because I don't know what the circumstances are. That's why I go to ponder the evidence and decide from that point.
Okay, so can we agree then that although that's those types of characteristics or character, as you said, are something to consider, they're not the end-all be-all, and you can keep an open mind to the testimony. Does it fit with the other evidence in the case? That sort of inquiry.
Definitely, I think considering everything is
okay, as opposed to
You
being
don't put
the
a
type of
diplomatic
person
plate
that,
on it.
I hear they're a felon, I'm done. I can't hear anything they have to say.
I think that's a very negative thing to think that way.
Anything else during my time up here where you were bursting at the seams to share something with me? Okay, thank you. Nothing further.
They might be nearing the
Parties
end
at
of.
this point can join me in the jury room along with the court reporter. For everyone else that is going to remain in the courtroom at this time, I'm going to instruct you once again, do not discuss the case with each other or anyone else. If you do need to stretch your legs or use the restroom, you may do so, but you do need to return to this courtroom. We're in courtroom 3G. No one is to take a tour of the courthouse by themselves. Please come back to courtroom 3G as soon as you finish with the bathroom, using your phone or stretching your legs if you need to. If the parties can please join me in the jury room.
Okay, when the judge says parties join me in the jury room, what he's talking about is you've now asked all your questions of the potential jurors. You know everything you need to know about them to qualify them, to get them ready to hear this case. And now you get to decide if you strike them or not. Which one do you want to kick off? And so they are very, very, very close. We might have opening arguments today. So, all right, let's go back to court here while we wait for that to happen. The judge has a chair you like to. Oh my goodness, Zimmy, this judge has a phenomenal chair. tufted, high back, leather, everything that my chair isn't. I did like the "Don't Get Brazen with Me." That was a good. I think we got that a couple things. I think we had a similar moment in ZA as well. Do we know of any courthouse that hire tour guides? I imagine some historic ones probably, because you get the schools that bring the classes in and check it out for the day. How bad does your back hurt after a day of streaming? Laura, fun fact, it doesn't. Probably because the muscles that I use to stream all day long, I've been using for 3 years. Now, I stood on the ladder and worked on the roof, patching, cracking plaster in my house for 30 minutes, and my calves were sore for 2 days. So my back muscles are great, but other muscles just don't get exercised. So, courthouse Becky gives tours for a fee. At 100,000 subscribers, I get a chair upgrade. Okay, share this with your friends, guys. We need 40,000 more people to come in here because I could use a new chair. Oh man. Yes, Camilla activated the hush in the middle of it. She couldn't help herself. All right, still waiting for some sort of action. Imagine we're either waiting for word from the deputy or maybe the deputy's like, hey, I'm almost there. Give me 10 minutes. I can see the judge waiting, give it, half hour or something. Never fracture your L1. Your back will hurt all the time. Pam, I'll do my best to not do that. Covington isn't close to Atlanta. Did rebuttal start yet? No, it has not. We still might have one more witness. I bet you'll be able to get a new chair when those Brewers win and Ivan pays that Bitcoin. I think we could put a chair in the budget then. Oh, man. Have you ever thought or asked Ayden to be on your show? I've not. I don't do a ton of collaborations. I have been on a couple other shows. I've been on with Ian a little bit for his fundraiser. I was able to, Peter Tragos invited me on for a quick interview on The Lawyer You Know. I've popped in for a couple birthday streams and things like that. I know I'm not a lawyer, right? I know I don't have the legal mind and training to speak with authority on some of those topics, and I do feel a little bit outgunned in those environments. What I'm good at is sound, is audio, is bringing you the best audio from court that we can. I've been on Court Confidential a couple times. Josh makes it easy. That's great. I love that. We've had Dr. G on here a few times. We probably should see if we can get him on again. But with Turtle Boy specifically, there was a lot of out-of-court drama in the Karen Reed trial, and I realize there's a ton of stuff, and I think Karen Reed owes Turtle Boy a big thanks for what he did on the trial, for the publicity and things like that. I don't think it would have had anywhere near the coverage that it did without what he did. That being said, I'm not a big fan of everything he did. Thank you. So I've tried to not go into that. I'm not here to point fingers at him. He does what he does well. He does it differently than me. We're very different. But just I haven't ever wanted to go to focus on that portion of the case. Need a few Alessi clips. So what could be more egregious? Blue Star, thank you very much. Peter is absolutely amazing. I think I told him, I'm not sure on his live stream or not, but I know I told him that I wouldn't be doing this if it weren't for him, because I had to get my wife to sign off on the whole idea that I was going to do some content creation regarding the law and legal cases. And she's like, how does that even work? And I said, let me show you. And I showed her the lawyer you know. She's like, oh, I see. Okay, and that's why I got the green light.
We're going to go back on the record.
Right, here we go.
Mr. Wolfenbarger is present here in the courtroom. We took a break while I got an update from the Sheriff's Department's Warrant Division as to the likelihood of getting that witness served with a warrant and or delivered here in execution of that warrant. And so here's what I have been told. So I've spoken directly with one of the higher-ups in the Warrant Division, and that warrant has been given to the nighttime crew, the evening warrant server guys, and I'm told that they're also going to notify Newton County, which is and ask Newton County to ride out, which is where Covington is located, I think.
She's not going to be here.
And that they believe that they will be able to provide the court with an update by, certainly before 9 tomorrow morning, that either they have secured the witness and are prepared to deliver her to the courtroom to testify, or that what I think is likely realistic, if she's that reluctant, is that they went to her house and knocked on the door and nobody answered. And that they have attempted to secure her and not been able to. So for that reason, if the defense's request is that we have a continuance until tomorrow morning, then I'm inclined to give one. But as I said before I left, and you can make whatever record you want to make, I would not be inclined to, as long as a reasonable effort has been made to execute that warrant and secure that witness's presence here, I wouldn't be inclined to delay things any further. Beyond tomorrow morning. Questions, thoughts, concerns on that issue? Mr. McDermott.
Well, you've basically already given a ruling. Your inclination is your inclination, but I think the witness is important given what's on the record and what we need to put on the record. And I subpoenaed her a long time ago. This is, I've made a great effort to secure her to be here. So, I would request, I understand the logistic aspect of it and the difficulty for the jury and whatnot, but I would request a continuance at least through Monday.
Wow.
If need be.
To do what, though? Right? If the warrant division, sorry to something, if the warrant division is going to go to her house and either interact with her and say, come with us, or you have to appear, or get no response, then what would delay, if they're going to do that tonight and report back to me that they did that one way or the other, then what would there be a need for a further delay?
Well, sign a no knock.
Yeah, obviously, you can't know if she's just not answering the door or if she's fled somewhere. So
right, and I don't know anything about her criminal history, but I don't. My point is, it's a witness warrant, right? So yes, she hasn't complied with the subpoena, but.
You have more power than just to grant a continuance for one day, though. There's lots of contempt power there that you can use, and I would request that there be more than one effort made knocking on her door. That's all I'm saying.
Okay. And that's really what I was trying to get to, is what else would you have me do other than what they're going to try and do tonight? So I understand further efforts.
I'm sorry.
Go ahead.
I'm really sorry. There's a provision, of course, in the evidence code in the same section on enforcing subpoenas that says that in such cases, secondary evidence may be used to supplement their. I know you can't give an advisory opinion, but I already talked about possibly playing portions of the tape. I'm not sure what other remedy there might be in that regard. I would be happy to hear your thoughts and anything you've done in the past in that regard.
Ms. Hilton, what are your thoughts, ma'am?
Yeah, we would be objecting to any, I guess, a couple of issues. So one, as far as a continuance, the state doesn't object to a continuance to 9 o'clock tomorrow morning. At that point, I think I was taught in law school, don't make promises at opening that you don't know if it's going to happen or not. And so, Mr. McDermott keeps saying, I made these promises in opening, I made these promises in opening. I don't think that determines whether or not this case moves forward in the manner that the court wants to, just because he said it in opening. As it relates to playing portions of this witness statement without the state being able to cross-examine, Your Honor, I think that we will be objecting. While she might be unavailable, we've never had an opportunity in any previous hearing to cross-examine this witness. And so we don't believe that the unavailability hearsay statute would apply in this case because we haven't had the opportunity to cross-examine her.
You had an
So
opportunity, you just
playing
chose
this
not to.
statement, we believe would be improper.
They were notified she was on the witness
Okay.
list.
And then the next question is with or without that witness, right? If the defense either has that witness and has her testify or doesn't have that witness and then I guess calls any other witness it may or may not have tomorrow morning. And then I guess we're going to delay the state's rebuttal until tomorrow?
Yes.
Okay. Have you actually had an opportunity, not that I'm necessarily inclined to, given the vagaries of what's been represented to me, but have you had a chance to actually listen to whatever that witness has said in whatever recorded statement Mr. McDermott provided to you?
I just started listening to it. I'm probably about 12 minutes in, so I have about 20 more minutes to go, Your Honor.
Okay. Okay. So I think what I'm going to do is excuse the jury, have them go home and come back tomorrow morning at 9, or 9:30, excuse me. 9:30. And we will expect either a witness or the defense to rest. And then the state will have its rebuttal, which we've already discussed we all understand will be rebuttal of something that the defense actually put on or created an issue about. And then we'll plan for the jury to get the case tomorrow. In the meantime, after I send the jury home, I would like to have the actual charge conference and any other matters that we need to take up. Anything else that y'all need me to address before I bring the jury in and send them home?
Nothing from the state, Your Honor.
Nothing from the defense.
Okay. Can I have the jury, please?
You will bring the jury.
If you will bring the jury.
Little Judge Newman throwback there. All right, so the jury's going to get excused. We're going to go home for the night. We're depending entirely on the overnight crew on the warrant service team to serve this witness. I would be shocked if somebody around this case hasn't already reached out to her and said, hey, little bird told me that they're coming. I'm surprised. I would be very shocked if the witness didn't know this was going to happen. But I don't have a lot of faith in the overnight crew on the warrant service team in Fulton County.
Bring the jury.
I'm just not sure that that's going to be like a done deal. Yeah, if she's watching, that's another big problem. She should not be watching. The fun fact is, Your Honor, can you turn the mics back on? It's like, it's not my fault. I had nothing to do with it. But I'm going to go ahead and send you home for the rest of the day, and we'll see you tomorrow. And we'll come back 9:30 in the morning, and we'll start from there. It should be the end of the case tomorrow, but it's out of my hands. And she's buffering. She's still buffering. She froze. All right, she's frozen. She's thinking, or she read something very, very interesting. We're not getting any audio there, so if it comes back, we'll jump back to it. Right now, the judge and the lawyers in the Donna Adelson case are crossing jurors off the potential list. And once they've all made their strikes, we might get opening statements. That'd be cool. Can't you do Zoom? I don't think she wants to do Zoom. If the unavailable witness, camera battery died again. I think they're like charging one and then swapping it out and charging, and you can't charge as fast as it uses the battery. If there's a witness who's unavailable, that warrant, it will still be there. When the trial's over, it's not like, oh, well, trial's over, never mind, cancel the warrant. No, that's going to be out there. And Wendy will have to face justice at one point or another, failure to return to respond to a subpoena. And that is going to that's going to be interesting. I think they just got excused. Because usually judges do not take lightly to people flaunting the court's authority. This particular judge does not seem plussed about the witness not being here, but she's put it all in the defense, which I think is wrong. The defense has filed the proper subpoenas. They do not have the enforcement power. As soon as they found out, they requested the assistance of the court, and the court's like, you take care of it. I don't know. You ask the sheriff to go find them. And if they don't, then it's your problem. I'm not a big fan of that. I think the judge should step up a little bit and be, not in my court. You don't do that in my court. Head hurts with this trial, says Barb. Wait till the next one. It's going to be so good.
Identify any typographical errors or anything, please bring them to my attention, because I like to fix them where I can. Some of them y'all have already brought to my attention.
There are some typographical errors. Here comes the audio. It's going to kill us. I'm sorry. Court TV.
Grave suspicion, which was requested by the defense. Witness impeached. So we discussed witness supported, which we agreed to jettison yesterday because it hadn't been, no one had attempted to rehabilitate a witness in that manner. We didn't actually discuss tailoring of witness attacked, but tailoring it to the evidence, I didn't hear, thank you, I didn't hear anything about, I mean, certainly I've heard some intimations of bias generally, but I've not heard bias in the particular way that it's contemplated here. What are your thoughts, Mr. Samuel?
We anticipate it does, 7. That's our thoughts.
I mean, I don't think it should be there is my point. I've not heard, while I've certainly heard general implications of bias based on parties' relative alignments with one another, I've not heard bias demonstrated in the particular manner that it's contemplated by this instruction.
The state agrees, Your Honor.
State what?
Agrees.
Just 1 second.
Sure.
I'm just looking at 131. You don't mind if we sit down, correct?
No, not at all. Yeah.
The original version had 3 bullet points. I'm trying to figure out what happened.
Right, but, well,
First
because
one's gone.
the first one's completely gone because nobody had any testimony about reputation for truthfulness.
Got it, okay.
And this one is highlighted because I thought it was a closer call because obviously parties are always going to talk about that people have biases. But this bias is supposed to be presented in a particular way, and I've not heard any such evidence.
I see what you mean. Okay, so instances of conduct of the witness, right?
Right.
I don't see that.
So my inclination would be to take it out, and the only one that would be in would be criminal convictions.
Right.
Excuse me. Prior statements. Okay, so Ms. Hilton, I had discussed with you yesterday this issue of immunity or leniency granted a witness. Mr. Samuel has made the argument that the case law is that the grant of immunity is so broad that it is essentially in service of any time that witness ever testifies about those actions, and therefore it's a relevant consideration. I had expressed yesterday that I wasn't sure if there was any particular case law on this point, but that at least from a plain language perspective, the pattern charge is written in a very, very general sense.
I think we're going to have opening statements today in Donna Adelson. It's going to be awesome.
Course indulge for one moment.
Sure.
While they're talking, can I ask a question? Or I lost track of. Is what's on the screen going to be in numerical order, or are you skipping?
No, they're in the order.
So 13142, which is witness supported, is out. Witness impeached, well, that's what's on the screen.
13145 is just the standard. This is what impeachment is.
Okay.
It's a little bit out of order because to me, you need to tell a jury how to impeach what it means to impeach a witness, and then witness attacked is there, but witness supported has been removed based on our conversations yesterday.
And you'd have prior statements.
Yep.
Okay.
And now we're on immunity.
Got it. Okay.
Your Honor, I didn't know if the court had had a chance to consider the Lee case and what it. I think what's a fair characterization of the case law is that it is not error not to give the immunity or leniency instruction. We feel that in this case, this is really meant, and if you look at all the case law, and there's plenty of case law in Georgia with Lee and a bunch of other cases for the Supreme Court that say that it's not error not to give it. I think that we feel like that unfairly having its own instruction is an unfair emphasis on immunity leniency, which is a very, very minor part of this case. Whereas it is adequately covered under the prior instruction based on credibility of witnesses, Your Honor. We feel like that having extra instructions in general runs a risk of confusing the jury. I don't know. This is relatively clear. I'll admit that, but we do feel like it unnecessarily highlights that. I don't think you need to give it. This is not the same thing. That is meant for a case where a co-defendant has got immunity. I mean, that's really what it is.
Right. We discussed that yesterday. I agree with you. That's typically where it comes up. But it is written in such a general way. I will say this, though, to your point, Mr. Wilson, Mr. McDermott or Mr. Samuel, I mean, even if the court doesn't give that instruction, you're still allowed to argue that she got immunity for assisting her husband in murdering people, right? I mean, isn't that the argument you're going to make, regardless of whether I give that charge or not?
Yes, but this is in the credibility of a witness based on being protected by the immunity, not that she's a bad person. This instruction deals with the fact that she was rewarded for testifying and is still under that protection. She's still protected by the immunity she received. If she
right, but it's not immunity in this case, is their point. And it does so in theory, it doesn't.
That's the door.
In theory, it would be lesser likely to influence her testimony here, I think is what the state is saying, because
there are so many parts of a jury instruction which, aren't the most important part of the case.
Sure.
I mean, most of all of this impeachment and witnesses and, are not critically important issues. They're just overall view of the types of things the jury can consider. Inconsistent statements. when you're talking about a credibility of a witness. Why bother talking about inconsistent statements? Why talk about prior statements and stuff? It's because you're giving an overall view of the types of things the jury can consider, not required to, but can consider in evaluating the credibility of witnesses. I don't think we should take out something just because it's not error to take it out. We should only take out items that are just completely irrelevant to the consideration of the case here, like we've been doing with a couple things now.
Okay. I'm going to look at it again. I did look at the general case law. I mean, again, I don't disagree with the state's assessment that this is typically intended for where a party in the case who's testifying has gotten immunity related to the case.
Melissa, thank you very much.
And I also don't agree with you that the case law says it's not error to not give it, because you can still make an argument. Even if I don't give that charge, the defense can still argue.
Well, yes, Your Honor. I just don't think it's. I think the case law is clear. It's not error for the court to instruct the jury.
But that's what I just said, right? I agree with you that it's not error to not give it.
Okay.
But I'm still not sure, under the facts of this particular case, that it's not implicated and that it would not be proper. So I'm gonna put a pin in that one and give you an answer in the morning. Okay. Single witness, defendant's choice not to testify, prior difficulties between the parties. So I would like to have a discussion on this topic because I think that although we have spoken in the generic about the prior difficulties that are alleged by the state between this defendant and the victim in this case, what I actually ruled was that those facts about those prior instances and allegations of physical altercation or abuse between the defendant and the victim were intrinsic evidence. And the law is clear that intrinsic evidence can be considered for any purpose once it's admitted. And this instruction says that the jury can only consider it to the extent that it demonstrates the state of feeling between the defendant and the alleged victim, which I'm concerned confuses the jury between the purpose for which they can consider it or not. Having said that, I also think that it might make sense to err on the side of giving this charge because the limited nature of the consideration might be better. I don't know. I do have concerns about it. I mean, as I said, the law is clear as far as I'm concerned that although prior difficulties, there is no case law that I can find that gives me a Venn diagram between prior difficulties and intrinsic evidence. There's some discussion in Carlson and some other things that, yes, the federal treatment of it and the state treatment of it are that prior difficulties are likely treated as intrinsic, but no discussion of the dueling standards that might apply. Because again, if it's intrinsic, then it can be considered by the fact finder for any purpose. If it's truly prior difficulties evidence, then it's limited in the manner that is described in this jury charge. Thoughts?
Well, I think I expressed my thoughts yesterday that maybe it's protecting the court as much as anything. It is if in fact the court says some of this is intrinsic, some of it's not, some of it went back years, some of it we don't even know what time frame they were talking about. If there was prior difficulties that were some of the earlier ones at one of the earlier Waffle Houses that goes before even July of '98. Rather than being intrinsic, that may have been would fit more than the Venn diagram part of prior difficulties, and at least we're protected from that. The real point is we don't want a jury saying you're guilty of murder because of the way you treated her before. That's the whole point.
Right.
I don't even know with intrinsic cases it wouldn't be improper. There is an instruction much later on. You can only convict him with that with which he is charged.
Right.
It's really reiterating that in this context. What happened to 13400? Did we just skip over that? Or
130.
13400. It just says limiting instructions?
There is not a 134.00. I think it's just the general proposition. Well, I'm sorry. Because there is no 404B evidence,
of course.
there is no need for the general limiting instruction charge. I apologize.
It came out with all the similars, right?
Yes.
Got it.
Okay, so hang on. No, I've lost it.
There it is.
Thank you. So yesterday, the defense has requested this charge, and yesterday the state indicated that they didn't have any objection to giving that charge. I think there's probably a reason to consider giving the jury the charge, because whether it's, I mean, I've ruled it's intrinsic, but it is in the nature of prior difficulties between the two parties. And so if the state doesn't object to the defense's request that I give the charge.
You know, what I'm trying to just think through is kind of what the court just said, because we have case law like Flowers v. State, in which prior difficulties between a party could be motive, or could be it coming for other reasons other than
because it's intrinsic,
right? And so,
Well, Flowers is a 404B case, to be clear. Well, there's two different Flowers, but one of them is a 404B case. It says even prior difficulties have to be evaluated under 404B. You don't get notice. That's the weird difference between prior difficulties and 404B.
Mm-hmm. So then the question becomes, do we get 134.20 and go back and get 134.10?
Hang on.
And when you find Hughes again, if it pops up, I can't find that citation for some reason.
Sure. So the purpose of the 134.10 instruction, as I understand it, and please, I don't want to make an error. If you think I'm making one, tell me. But the purpose of 134.10, as I understand it, is where you are limiting the use of that evidence. And my understanding is that when the court has ruled that evidence is intrinsic, i.e. necessary to tell the story of the murder itself, which, right or wrong, I have clearly ruled that that evidence was intrinsic, there is no basis to limit the jury's understanding or use of that evidence. They are allowed to consider it for any purpose to which it is relevant and admissible in the case.
Right, so then we would ask for 134.20 not to be given, so it does not limit the purpose for which we introduce the intrinsic evidence of the prior difficulties of between Mr. and Mrs. Wolfenbarger. So we ask that you not give 134.20.
Okay. Mr. Samuel, your position is you do want it to be given, correct?
For sure.
Okay. Right now it's in, and that's gonna be my additional homework. Let me give you the Hughes case.
Thank you.
Now that I have finally gotten my history on Westlaw to pull up.
All right, while she's doing that, FedEx did in fact show up. She read the note. She knocked on the door nice and loud.
Yes.
Signed for my package. Got a brand new hyperdeck. And a big shout out to Sweetwater for honoring their warranty and doing it all for free. I'll just send back the non-working one, and that's it. Probably will order something else from Sweetwater in the next week or so as well. But I did tell her thank you. She read the note. Our opening statements in Donna at Adelson starting today. I believe they are, but it's getting later and later. Like it's 4 o'clock right now. So it's possible. I mean, if we do opening statements, I would be surprised if it took less than an hour each. That's 2 hours. Yeah. Let's see. We're live twice at the same time. What? I only show one, Samantha. Did the Donna go live as well? No, it shows scheduled. I'm only live on the one. They can't mess up podcast day, for sure. It's earlier in Tallahassee. What's the time? Are they an hour? Are they central? Yeah, chat is live. Gotcha. Thanks, Samantha. I did make it public, so there are some people in there already. Sort of surprised my wife isn't home by now. They left like right before I started live streaming this morning, about 9:45, 10 o'clock around there. Trial begins tomorrow in Donna Adelson. Yes, and it's going to be great. I'm really looking forward to it. First of all, we've got an amazing judge with a personality. We've got...
Very bad at navigating my history. Give me a few minutes and I will find it before we call it a day.
It's my responsibility. You had given me 296 Georgia something, and I just couldn't... And then I tried to search Hughes plus intrinsic and couldn't come up with anything.
Yeah.
But that's okay. Why don't we keep going through it?
Okay.
We'll be here in court tomorrow to see what happens with the missing
Go
witness.
back to my jury charge.
You guys been looking for a case that whole time.
Okay.
If you don't mind jumping back and forth, I just found Hughes for you.
Thank you.
Megan, thank you very much.
Georgia 149.
6 months of fun, this channel and community.
Well, I want to look because there was, the case I was particularly looking at was one particular prior domestic incident. And when I was just looking now, I found another Hughes case that involved 3 brothers, and I'm not sure that's the case I was looking at. So I wanted to find it again, but it was specifically related. It talks about both prior difficulty and intrinsic, and it was, the admission was specifically related to a prior incident of the defendant allegedly slashing the tires, I think.
Oh, I saw that one.
Of the victim.
Okay. I ran across that this afternoon when I was looking. It just didn't seem to be the same. Anyways, my issue. So no.
Okay.
So 13430, yeah, that's next.
Yes, and I have tailored it. Right now, the only evidence is evidence that witnesses have prior convictions, and so I've tailored it just generally to that. So we had some discussion yesterday about identification, and there was a discussion of whether or not to give 13510 or some portion of it. Obviously, the second portion of 13510 is very clearly directed at people who are, stranger observations of, wrongdoers, alleged wrongdoers, and that's not really what we have here. The more I looked at it, the more I thought, if we're not going to give that portion of 13510, is there really even any point to give 13510 when 13511 says it's the state's burden to identify this defendant as the person who committed the offense, which is really what's at issue in this case.
Yeah, sure. We were going to, I'm not sure if the state requested it, requested it, or we were going to withdraw 13510.
Yeah, I think it's pretty standard for the state to request both of them. And so, yeah, I will remove 13510 with everyone's agreement.
Yeah.
Okay.
13430, because there are no prior convictions against Mr. Wolfenbarger, because he just had misdemeanors. There was no felony against Mr. Wolfenbarger was introduced. And you said against any, well, what do you have? Just a witness?
Yes, it just says that it's been tailored. You have received evidence of prior convictions of witnesses who testified in this case. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose.
Okay.
And then definition of crime, intent, no presumption of criminal intent, presumptions and inferences, malice, murder, motive, felony murder, causation in felony murder, aggravated assault with a deadly or offensive weapon.
Did you correct the typo in 21030?
I believe I did, where it said they, it now says he.
Okay.
And then there was some discussion yesterday that I don't think, setting aside for a moment the still pending DV motion regarding this issue of the offensive weapon. Do you have any, let's assume for a moment that I'm going to deny the motion for directed verdict and that the issue of felony murder based on aggravated assault is going to go to the jury. Typically, the charge of aggravated assault is accompanied where it's not like with a deadly weapon or a handgun where we all know it's a deadly weapon. It is accompanied by this charge, which I believe was requested by the defense. Any objection to that charge?
Are we talking 220, 23?
Yes.
Yeah, no objection.
Okay. Venue generally, the verdict, multi-count indictment. Alternates, etc. That's the entire charge. So I think, if I'm not mistaken, the parties are in agreement with the exception of the court's ruling on the immunity charge and the court's ruling on the prior difficulties charge, which, as it currently exists, the defense has requested, but the state objects to. Is that correct? Any other charges?
I am on the offensive weapon. That seems to me the same issues that are causing some concern about the directed verdict motion, why it doesn't apply to the jury instruction also. It seems to leave this so open they could decide that the act of dismemberment, the saw, was the weapon used, but that's not really in dispute. I
don't think so. I think the ME pretty clearly testified that those were post-mortem.
State must prove that the defendant assaulted another person with an offensive weapon
and caused the death.
Actually injured.
I want to change this.
There's no display of anything to the jury. How is there any manner in which it was used? There's just no evidence of that at all. The character or capabilities of the weapon?
I agree, which I expressed during my discussions with Mr. Fawcett about the directed verdict motion, which is, like I said, even assume for a moment that I'm like, okay, it goes to the jury. There's literally no evidence of a weapon. I understand the state's argument when we were having the directed verdict discussion was, well, she died in a way where we've presented facts that, could lead, a reasonable inference could be drawn from those facts that she died by homicide. And so then you're, I guess, and I agree with that, right? Which is why I denied the motion for directed verdict on the murder charge. On the felony murder, secondary, with the underlying felony of aggravated assault, that's what I'm still struggling with for purposes of instructing the jury as well, which is, how can a jury make a reasonable inference that a weapon was offensive if there's literally no evidence of a weapon? And I think I understand the state's best argument is that a weapon, in the very broadest sense, had to have been used to accomplish the death, even if that weapon was, I think your example was poison or something.
Right, and not only that, but I mean, I think getting back to the root of the evidence that came out, the reason why we aren't able to make those determinations is because the state in which the body was disposed of. And ultimately, I don't know how that's not akin to essentially, not that the court would have that intent, but rewarding the defendant for doing a good job making it difficult to make that determination. I think that there are facts and evidence. The judges, Your Honor, is going to give the jury a definition of offensive weapon. And it's up for the state to convince the jury that there is an object or enough facts and evidence that the jury can make those reasonable inferences that an object was used and that it fits that category that the judge is going to define as to what an offensive weapon is. I think that there is testimony from Dr. Gilbo, Dr. Terry, the investigator Miller, not just as the photographs, but the injuries, the manner in which they believe that the body was dropped off and murdered at a different location, that it wasn't sacked up at that location. I think all the facts in this case not just point to a homicide, but a homicide. We never said that she was killed with a saw, although that is still a possibility. She could have been. But we don't have the parts of her body that are necessary to make those determinations. And we don't have them because the defendant disposed of those parts. And I think that the jury has enough facts before it to make all those reasonable, common sense, logical deductions.
Mr. McDermott?
Your Honor, the state has to prove its case beyond a reasonable doubt from evidence, not from a lack of evidence. What he's arguing for is, court, please allow me some leeway so that I can prove this without any evidence. And if you don't, you're giving a windfall to the defendant because allegedly he hid the body really well and didn't leave us any evidence. That's not how this works. There's got to be evidence.
Well,
and you can't just say, we'll leave it an open door so that we can let them assume any possibility, like poison, etc. That is directly contrary to how this is supposed to work.
Well, it seems as if I have some additional homework to do tonight, but I already did because I took it under advisement. But
can I make one last correction?
Sure.
This is nitpicky, but I think the statute warrants it. 130.20 on direct and circumstantial. The last paragraph. You passed it.
130.20?
You're right. 130.20. The last paragraph excludes all reasonable theories of innocence. The statute says hypotheses. And I would request that be changed.
Okay. I will take a look at this. There are two versions of that pattern charge.
It came out of yours.
There are two versions of the direct and circumstantial pattern charge. There's the long version and the short version. This is the short version, number one. Number two, this has also been plain languaged by the plain language the pattern jury instruction plain language committee. So in an effort to get rid of big words and use words that are readily accessible is, I suspect, likely why hypotheses isn't there and theories is. But I will take a look at that.
Thank you.
An effort to get rid of big words. Is that like a push? Sometimes big words are the right words.
Anyway, all I was going to say, and I don't know that I'm saying anything that I haven't already said, but to be clear, the reason that I'm taking under advisement is I've already said I think there is evidence here that is sufficient to require the jury to determine if they believe that a murder occurred here and that Christopher Wolfenbarger committed that murder. Where I am having some reservations that I think I've been pretty plain about is while there are facts from which a jury might determine that a murder occurred and that Mr. Wolfenbarger committed that murder, aggravated assault requires that there be facts from which a jury could understand how that murder occurred and the manner in which it occurred. And that's what I'm struggling with, because there is no evidence of that. And the mere fact of death, I understand the very broad way in which the state wants me to interpret the aggravated assault standard, but I haven't finished looking at it yet, but the defense is at least urging that the broad way that the state wants me to interpret that aggravated assault isn't as broad. They're not actually allowed to have it interpreted that broadly because, for example, and again, I'm just saying this is what they've argued yet because I haven't had a chance to spend some time with it, but that other methods of aggravated assault are not available to the state, like aggravated assault strangulation or other things. And yeah. Well, that's why I mentioned it, because I don't know that I'd heard a clear response from the state on that point.
Well, I would like to pose a hypothetical to the court, for the court to consider. I think well, let me, if I could.
Sure.
So I would say let's say we have an example where an individual is found deceased and they have a significant injury to, say, their head, and you have another individual that just no other evidence, but they confessed to it, I did it. And you don't have any other facts but that. You ultimately would have evidence not of an object. You wouldn't have evidence of a weapon that was used. All you would have at that point is the confession tying the person to the crime, the injury, the death, and then you would have the injury itself. That's the only thing that the state is missing in this case, is a visual depiction of, that we could say definitively where whatever impact happened. We don't know if it's bruising on the neck. We don't know if there were hand marks, that she was choked, and that because of the state of her, we don't have the marks on her neck to show the jury, hey, this is why we believe she was deceased or asphyxiated, because she's got these marks on her neck.
So, forgive me for interrupting, but two things to your example. Number one, I'm not sure I agree that example is apt here, because if you had a significant head injury, like, for example, if the skull in this case was distended in some manner or injured in some manner, then the existence of the injury, right, could be used as some evidence of the offensive nature of the weapon that was used to cause a violent injury or an attempt to cause a violent injury. And that's number one. But number two, and my real point is what you just said, which is you've mentioned a couple of times whether there's bruising on the neck or if they use their hands around the neck. What I haven't gotten a clear answer to from the state is a response to the defense's argument that ag assault strangulation is a different crime that is not charged in this case, and the state can't argue it.
It is a different crime, but aggravation strangulation can be charged with regular aggravated assault, or it can specifically be charged with aggravation strangulation. And the state would be authorized to make all those arguments and close an argument. I don't think that specifically charging it with family violence aggravated assault or aggravated assault strangulation prevents the state from charging the cases as a plain language aggravated assault in both of those instances and still prosecuted for the jury. So I don't think that charging it specifically as a strangulation prevents us from arguing that that's one of the possibilities that you could have been murdered or one of the matters for death. The charge of aggravated assault is meant to be brought, especially when there's an issue as to the date in this case. There is an issue as to the date. Especially when there's an issue as to being able to prove what type of object. We're going to have this issue anytime there is the lack of evidence because of the actions of a suspect or a defendant. This is always going to be an issue, but that is why the statute phrases the options as offensive weapon per se, and it specifically relates and mentions objects, because it says objects because there are limitless, depending on how the objects are used, it could become dangerous and cause serious injury.
The object is not your hands.
The state's making ultimately is that this is not like any other situation where you have pieces of evidence that's missing. The jury has the facts to make those conclusions based off of all the facts in the case. The injuries that occurred before, the injuries that occurred throughout the year, the manner in which her body was disposed of, the manner in which it was assaulted and cut, dismembered, and I think that all of that is something that the jury should be able to consider in that determination as to whether or not the state met its burden of proving felony murder.
You're making an argument that you need a new job, sir, because I do not believe it's a good argument.
So, just to be clear, so I know what my homework is, I'm going to look at the immunity charge. I'm going to look at the prior difficulties charge, the theories versus hypothesis in the circumstantial evidence charge.
At least mine's easy homework, okay?
And I already have under advisement the DV motion on the ag assault felony murder. And I will say this, if I allow that charge, that count to go to the jury, I expect that what I will do is give the patterns that are here and let everybody argue about what the questions that those patterns beg, right, that the state doesn't have answers to, that I've heard from the defense.
Judge, that's weak.
Your Honor,
Yes, ma'am.
I am looking or researching. I know that we've had some statements come in, prior inconsistent statements come in. I know we have the prior statement charge and rules of credibility, but specifically that the prior inconsistent statement can now come in as substantive evidence, and so that they can take what the prior inconsistent statement was as fact or as substantive. And so I don't believe that the prior statements charge adequately addresses that. So I'm just trying to, and we don't have a pattern charge on that specific topic, so I may be emailing the court a
that's fine.
non-pattern charge.
Okay, I mean,
I looked for a prior inconsistent statement with the substantive portion. I didn't.
But that's, I mean, that's because it's a relevance ruling, right? Prior inconsistent is whether it's coming into evidence because it was disputed. And I believe those statements are in evidence, right? So the question is to tell the jury what to do with them. And I think the issue is go back and look at the prior inconsistent statement, the prior statements charge. I think that the pattern discussions indicate that it was intentional to do a broader, more general statement about the purpose of prior statements. And if you look, it doesn't say that you can only consider it for its, inconsistency. It's for you to decide why they would have said one thing before and said something else now. So I believe that that's why there's not a pattern that specifically highlights that it wasn't inconsistent or not inconsistent, et cetera. But if there is other language you want the court to consider, I will, of course, consider it.
Thank you.
Anything else from anybody before we adjourn for the day?
Nothing.
Okay. I will see you guys in the morning at 9:30. Yes, ma'am.
That is terrible. That is absolutely terrible. The judge saying, I am still struggling. I don't know how to read the pattern jury instructions to the jury because it won't make sense. The way the law is written, we're asking them to convict convict this individual on evidence of assault with a deadly weapon, an object. Not a person. Okay, assault with something. That sounds like there's like the person, and then they're with something, right? There's like two things. The guy has a hammer. Assault with a hammer. There is zero evidence, none, that anything was used. There is equally, and I have no any inside information. There is equal evidence that. There's equal evidence that she died of a drug overdose, that she died in her sleep, that, and I don't know, he just didn't want to pay the funeral fees. There could be all sorts of other crimes, but there's zero evidence that it was assault with a deadly weapon. She could have died other ways, and there's just as much evidence to support those other ways as there is to say that he used a knife or strangled her or used, any other poison or anything else. And for the judge to allow this to go forward saying, I don't know how to do this because we've got that whole language about the weapon. You don't. This is your sign, Judge. This is your sign. If you don't know how to do it, you're like, I don't know how do we get from there because there was no evidence of a weapon. That means the element was not proven. The element of that charge was not proven. And you grant the JOA on that charge. And you throw that one out. Let murder go forward. I understand your reasoning. There's a sliver of enough evidence to a jury could reach that conclusion. That's great. If they do, that's great. But not this one. And man, I'm frustrated. I wish we had some of the different. I wish we had some of the YSL defense lawyers on this case because I don't think the argument is being adequately presented to the judge. And I mean, I know they've preserved it for the record, for the appeal. It's fine, but you never want to win your battle on the appeal when you can win it in court originally. I personally think he did it. I'll tell you where I'm at. I think he did it. Odds are he's the guy. There's a good chance he's guilty. The standard of proof is higher than that. And this is one of those situations where we say it all the time. It's better that 100 guilty men go free than an innocent man. Maybe this is one of the guilty men going free. This is that principle at play right here. There's not enough evidence to convict on, at least especially that second charge. So, what is JOA? A judgment of acquittal. That's where the judge makes a ruling before it goes to the jury. Sometimes it's called a directed verdict. Sometimes that has to do with after the jury comes in. Depends on the state. But when the state is done presenting their evidence in the trial and they say the state rests, the defense stands up as they did here and they say, we make a motion for a directed verdict or a judgment of acquittal because the state has not proven what they're required by law to prove. And it's by law. You can spell it out in their check boxes. We have to prove that this happened in this county and that the person is dead. And, there's check boxes you have to prove on each one. They call them elements of the charge. And if they cannot prove the elements of the charge, the jury would not be able to convict because you can't, without those elements checked off, it's not beyond reasonable doubt. Okay? If we're sitting here and she just disappeared, let's say head was never found, limbs were never found, there was no blood, there was nothing. She just was gone. You could be sitting here in trial and you can't prove that she's dead. You can't prove she's gone. We can't have a murder conviction if there's a chance she's still out there. She's just in hiding. She just didn't want to be found. A lady from Texas just got found in Scotland, living in some weird communal thing. People do that. Now, this didn't happen in this case. We have a body. We know she's dead. But if there's an element of the charge that has not been checked off, then when the defense stands up at the end of the state's case and says, Your Honor, move for a judgment of acquittal, you've got to enter this JOA because the jury cannot reach a verdict. It's impossible. Legally, they can't. The judge looks at it and says, You're right. It wasn't proven. Judgment of acquittal. And the jury doesn't have to do any work because the judge looks at it on a face value and says there is no legal way for the jury to reach that conclusion. That's what it is. All right. Georgia's directed verdict. Talk a bit more. We're almost at 1,000. Okay. We'd love it if you guys could click the like button. There are 858 of you who have. We'd like to get to 1,000 on each live stream. So that would be fabulous if a few more could click the like button. Where we are right now in this case, obviously, we have one more witness for defense. This is a witness who does not want to testify for the defense. She does not like him. She thinks he's the bad dude. She doesn't want to be on that side called by the defense. And she initially said she was going to testify. She was issued a subpoena, and then she didn't show up. Defense reached out to her, and she's like, over my dead body, and maybe used some other choice words. And did not show up. So there is a summons. Let's put it this way. There is a arrest warrant that has been signed and given to the sheriff and given to the night crew. So they're going to go out and try to get her tonight. And we know who it is, and she knows who it is, and there's a good chance that she knows they're coming, which means there's a high likelihood that she's not found. right? It's very easy to avoid a warrant if you know when they're coming and where they're going. So there's a high likelihood she's not going to show up. And we're going to have an argument tomorrow morning of whether they're going to allow in the recording or a transcript of the recording of the phone call, which was not a sworn statement, but a discussion between the lawyer and her. We've got all sorts of issues there. But either way, tomorrow we have closing arguments in this case. And in Fulton County, which is, that's where we're in Fulton County. But over in Florida, that's what I'm trying to say. In Florida, we have another trial, which is about to start tomorrow. And that is the Donna Adelson trial. Donna Adelson is going to suck you in. If you have plans, if you have a vacation in the next, between now and September 3rd, you might want to reschedule it. This trial is going to be a doozy. Assuming that nothing terrible happens like a plea deal tomorrow morning, which we've had a couple of those lately. This one's going to suck you in, and you won't be able to tear yourself away from it. We have great audio from court. We have a great judge. We have phenomenal personalities on the lawyering, and we have just an intriguing story that's ripped from the headlines and has well-known names, well-known locations. Just every bit of the Hollywood writers could have come up with for a crime mystery is in this one. So please be here for that one. That would be great. Rate the Florida State Seal, please. Well, let's take a look here. Right. It's good. It's old style. I like the old style with the ship, the sailing ship. It actually looks like it's got a pow. It's not a sailing ship. I take that back. It's got a paddle wheel, so it's a steam. There's the clouds of steam. Okay. The flowers. What is she doing with the flowers? Is she like dropping a continuous stream? Are they like on a chain or something? I don't see an alligator. I'm pretty sure that if this scene were recreated in any part of Florida where you could recreate this picture, there would be an alligator in the picture. So it's missing some things, but
I'm trying to have court. Don't raise your voice again.
Don't raise your voice again. Thank you, Judge. It's not bad. It's not bad. I like it. It's a lay. It's laying on the ground and in her arms. I'm just wondering how there's a string of flowers between her hand and the floor. She's already sewn them together. Anyway, let's see. Georgia and Florida, competition in weird cases. Georgia's had a few. Fulton County, oh my goodness. The argument the prosecutors have made in Fulton County, it is a terrible argument. Terrible, I think, because prosecutors should be seeking the truth, and they don't. In this case, they seem to be seeking a conviction and doing anything they can to seek that conviction. She's littering flowers. Is that what it is? We're up to 938. So just if we can get 62 more people. I'm good at math. 62 more people to click the like button. 61 now. We could hit that 1,000 mark and let everyone go home. 55 will do it. Hey, Colburn says, I can tag now. Woohoo! That would be great. They're growing around her. That's probably more accurate. I think the foliage in Florida is quite aggressive and will grow over you if you don't pay attention. Keep it at bay. 45 more. We just have to hang out here until this is over. Basically, what we're watching right now, we're actually hoping, we're not going to go anywhere just quite yet. We're hoping that we get word back from the judge here, who is currently in the jury room with both parties. He's with the defense and he's with the prosecution. All the jury members are walking around the courtroom, but they're not supposed to take a tour, and they're supposed to come back into the courtroom in just a little bit. They're going to find out if they actually serve on this jury or not. We have more jurors than we need who have passed the test so far and have not been excluded. But in that jury room, the judge and the counsel are going over each juror. I think they normally start at the lowest number, and they alternate back and forth and see if defense wants to strike that person or keep them, and then prosecution, you want to strike the next or keep them, and you can just zip through. And as each person is passed, they get added to the jury pool, and you've seated the jury, and then you seat your alternates, And then you say, are there any other strikes you have, and things like that. It's sort of like repeating the process a couple times, but you get to basically eliminate the people you don't like. You really don't want this guy on your jury. This person, he says he was a member of a jury before, and he was really disappointed because they didn't convict the guy. And he was, it's like, well, I'm not sure if I want you on the team as a defense guy. I just don't want that on my team. So they're going to eliminate the people they don't want, and we'll be set to go. 6 more people. Wow, we're at 994. So you click the like button, 995. Everyone just wants to be number 1,000. That's what it is. How many jurors and alternates in the Alderson case? I think they have 22, 24. I forget how many made the cut. They're more than that fits in the jury box. I wasn't listening very closely when they said what number they were. But 12 regular, 6 alternate. Rocky, thank you for that. That sounds about right. That's on the high end, but it's a long case. It's a big case. They usually, when there's a case that's going to go for several weeks, they like to have a few extra alternates. You mean basically we're watching a complete train wreck in real time? Thank you. Suddenly we shot over 1,000. We've got 1,016. So everyone wanted to be number 1,000. Thank you for the 1,000 likes. That is awesome. Does wonders for the channel, and it's free. Can you go through why you lean towards guilty?
I'm trying to have court. You don't raise your voice again.
I'm sorry. Why I lean towards guilty? I don't. At least not on this first trial. I think he's guilty. I think there's a good chance he did it. It's all circumstantial. I mean, he's got a DV case against him. That he's charged with assaulting her. There's evidence that he did that in the past that has been brought in that the jury's heard. You've got, it seems to match up where the body was and where he was, and the availability of the saw and things like that. There's things that could match up there. So it's possible, but it doesn't get me past reasonable doubt. It could be something else. It could have been somebody that she was seeing, right? At the Waffle House or somewhere else. So I'm not at guilty. If I were on the jury, I'd vote not guilty. Not because I don't think he didn't do it, but I don't think the state has proven it beyond a reasonable doubt. Let's see. 12 for murder trials plus 3 alternates. That's like the bare minimum. Podcast tonight, 8 p.m. on this channel. If you haven't been here for a podcast before, you should try it. It's a lot of fun. Check mod chat. Thank you.
Scratch all that. Oh, that was terrible. I apologize.
Let's see who's I'm looking. Okay, thank you. Let's see. Welcome, Catnot Williams. Good to have you here. Catnot Williams is a name you've probably seen if you're on social media following true crime. Let's see. Trash bags from the Waffle House. I don't think there was any direct connection there like that. I'm appalled. I really think that Fulton County specific. I'm not saying the specific. It's not just Miss Hilton, right? Fulton County has problems in the legal system. They're incredibly slow. I think there are many people who are guilty as sin, who should be let out right now because their right to a speedy trial has been violated. I think that should happen. Fulton County is just way behind, and maybe it's because they just have so many people. They do cover Atlanta, right? Yeah, there's Judge Manning. I just think that the justice system does not function as it should in Fulton County. And part of the problem, from what I've seen, is the way, that's a nice chair as we wander around the courtroom. Part of the problem is the way the prosecutors are handling this case. They've done a shoddy work as far as organizing this, as far as discovery. This is a cold case, and you haven't turned over discovery?
At this point, you will be free to collect your things, and you will not have to return at any other point during this process. So
they've got a jury.
Allow the court reporting to get so.
They've got a jury. Is this opening statements? They just excused the alternates. This is in Donna Adelson. We're looking at some cool hardware on the wall. That is a IP to HDMI converter.
Madam Court Reporter, sorry to get ahead of you. At this time, I'm going to announce the numbers that have been excused, and you will not need to return for any further jury service in this matter. We give you our sincere thanks for honoring your summons and participating thus far. Juror 24, you are excused. Juror 22, you are excused.
Please take your dozen eggs and go.
Juror 6,
they're
you
leaving.
are excused.
Right there.
Juror 7, you are excused. Juror 8, you are excused. Juror 9, you are excused. Juror 12, you are excused. And Juror 26, you are excused. Watch your microphone.
Juror 6. Wow. Asked a lot of questions of that juror. I want to hear what he tells the jury here, so just hold tight for just a second as far as schedule.
Juror 19, you are excused.
Oh, he's still excusing him.
And Juror 16, you are excused. We are also going to reconfigure the box at this point as well. Juror 5, please shift down next to Juror 2.
This assigned seating, apparently.
Juror 23, take the seat to the left of Juror 5. Juror 11, take the seat next to Juror 23. Juror 13, please come down to the first row and sit next to Juror 11. Juror 14, please take the last seat on the first row. Juror 17, please shift down to take the seat on the second row closest to the wall. On the second row. Yep, that's it. Juror 18, please take the seat next to Juror 17 on the second row.
This is hopefully the worst audio we have in the trial.
Juror 20,
it's well mic'd.
Please take the seat next to Juror 18. Juror 25, please take the seat next to Juror 20. When you hear your number, please walk up and take the first available seat. Juror 27. Juror 28. Juror 29. And last for the second row, Juror 30.
So they're seated in order.
The seat closest to the wall on the third row, Juror 31. Juror 32 to follow.
This is their final configuration for the trial.
Juror 33 after that. Once you are seated on the third row, if you can hold up your paddles so I can ensure you're in the right positions. 31 closest to the wall, 32 next to her, thank you, and 33 right there. Juror 34, please come up as well.
These are the original juror numbers.
Juror 35.
We don't actually have 35 jurors.
And juror 36.
They might be renumbered here.
It will be another few minutes before we resume. If anyone needs to use the restroom, please do so at this time, or stretch your legs.
We're doing openings.
We will get started as quickly as possible. Once again, you are not to speak to each other or discuss this case while we are still going through this process. We will resume in a few minutes.
All right, while they take a break, here's what we're going to do. We're going to portal over to our Donna Adelson live stream, which is ready to go. That way, when people are watching this on replay, they'll be able to find the openings. It sounds like we were going to openings. We need a new counter. We need something else. We had anything goes counter. We're going to have to count something else during this trial, so be on the lookout for that. By the way, Kat Not Williams, welcome. Another content creator here on YouTube. Also, I run into her mostly on Twitter because we're both creating at the same time, I think. But welcome. Good to have you here, Kat. Thanks for popping in. I think that's it. I think we have opening statements in Adelson today. Okay, sudden portal. It's just going to be moments. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again in just a few minutes. In just a few minutes, which what we anticipate to be opening statements or possibly just jury instructions. I don't know. It's late in the day. It's 4:47. And the judge says, quick, go use the bathroom. We might be working late tonight. Podcast still starts at 8, so I might not have a break between opening statements and that. I do not expect to see any testimony in this case today, but opening statements might happen right now. So buckle up. Here we go. We'll see you guys after this. Bye-bye.
I'm trying to have court. Don't raise your voice.
Because he's the guy.